Good morning, everybody. Happy Monday. Welcome to the Courtroom Files Live. We will start our day with first appearances. This is Judge Mercer in Florida.
I'm a Daniel Public Defender. You see and hear all three of us, Corporal?
Yes, sir, we can.
Right. First case is Crystal Carnley. Ms. Carnley, good morning. Ms. Carnley, you're hearing case 24-361CF. Ms. Carnley, there's a failure to appear warrant issued by the circuit judge, ma'am, for that for the case you had down there in circuit court. It's failure to appear for a pretrial. The warrant's been active since December of 24. So, Ms. Carnley, I did take a look at the file, and I saw where the state had filed a motion to revoke the bond in this case based on your new arrest in Holmes County. So then I took a look at the case in Holmes County, and I saw, surprisingly, that while the state, you had filed a motion to revoke bond, the state attorney's office in the other county gave her a PTI while your motion to revoke bond was pending. So obviously, not obviously, but it appears they didn't look at what you were doing over here, even though it's the same state attorney's office. So, Ms. Carnley, there's clear, let me finish. There's clearly probable cause that you committed a crime while you're out on bond. I read the complaint. The allegations are there was a paraphernalia pipe on your person. That's all I need. I'm gonna revoke your bond. So I'm gonna ask Mr. Mitchell to get me an order revoking your bond in the Jackson County case. So even though the failure to appear may be based upon being arrested somewhere else, I'm not really sure about that. Clearly, you got arrested while you were out on bond here, and clearly there's probable cause in the complaint. So I'm going to revoke your bond. I'm going to grant the state's motion, ma'am, and that'll put you on the next pretrial docket in front of Judge Garcia. I'm going to ask Mr. McDaniel to notify your attorney in the Jackson County case to notify the attorney of the situation that you're there with no bond. That'll prompt that attorney to come and see you. Lastly, well, I don't know if I can do a drug test because, yeah, she was arrested. She's on PTI in Holmes County. So let's get a urinalysis from her after first appearance, Corporal.
Yes, sir.
That'll kind of help the state and defense know how she's doing now on PTI and out on bond. Was out on bond. So Ms. Carnley, I'm gonna try to find out your next court date. So give us just a second. We'll try to see when Judge Garcia's next pretrial date is. Mr. Gill may know. He's down there in that courtroom a lot.
Yeah, it's a little. Oh, hang on, I got the.
We've got a calendar here, and it's usually right, but not always.
Yeah, I think that's right.
We think it's going to be the 19th of August. Go ahead, ma'am. You have any questions?
The only reason I missed court is because I got in a car wreck and was in a coma.
Okay. That has nothing to do with you getting arrested in Holmes County and being charged with possession, drug paraphernalia, and some felonies over there. So I'm revoking your bond because of the arrest, not because of missing the court date. Any other questions?
Okay. No.
All right. Have a good day, ma'am. Nicholas Prager, or Prager, not sure how to pronounce that. Prager. Mr. Prager, good morning. Mr. Prager, you're here on a charge of driving while license suspended or revoked knowingly. Mr. Prager, there is probable cause in the complaint. The criminal history I got was Florida only. So I asked the jail to send me an out-of-state history, and it shows some additional charges. So, yes, Mr. Mitchell, just a second. Let me ask the state a question. I don't want you to say anything that's going to hurt you. Is the state asking that he be held for Alabama or not?
I would say hold them for 10 days so that we can find out.
That's your request? Okay.
Yes. Which county is it?
Houston County.
It is Houston County. Yeah.
Okay. So, Mr. McDaniel, I know it's unlikely that they were going to come and get him, but the seriousness of the charge, along with the recency of the charge, makes me consider that may be appropriate, or at least until we can hear back from them. What's your thoughts on that?
I don't disagree with that. I just know that I've dealt with Houston County before. It usually takes them about 3 weeks to call you back. So they're not, I mean, it's not going to happen in 10 days. I don't care. I don't know if it matters how serious it is because unless you have a direct line with the sheriff in Houston County, maybe, but it just does not happen.
All right. So what I'm going to do is I'm just going to hold him until Friday. Now, let me explain that. You have a very serious sexual battery, what we call sexual battery. It's called rape in Alabama from 2 months ago. So let me finish. I think it's possible now that you've got new charges in Florida. I think it's possible that they'll seek to revoke your bond or your release status up there. I don't know that, but I want to see what they want to do. But I'm not going to hold you 10 days. The reason I'm not going to hold you 10 days is this. I've never had Alabama do anything within 10 days. I don't want you sitting here if they're not going to do something. So I'm going to ask Mr. Mitchell to notify the Alabama authorities. And if they seek to revoke your bond, then we'll see where they stand. If they tell us they're not going to, then we'll bring them up tomorrow and I'll release that hold. But don't try to post the bond, right? Don't try to you're not going to get out even if you resolve the new charge until Friday, unless Alabama says they don't want you. Now, in regards to the new case, the Jackson County charge, I'm going to appoint the public defender's office to represent you. And I'm going to ask that you listen to Mr. McDaniel, your attorney, sir.
And what I'm thinking about is, Mr. Prager, if you want to, talk to your attorney in Alabama, just tell him to give me a call. My name is John McDaniel, Public Defender's Office in Jackson County. He can give us a call at the Public Defender's Office. I know you said that he had some relevant information or whatnot, so just, tell him to give me a call and let me know. Your Honor, we're going to plead of no contest to the charge of driving license suspended revoked. Understanding he's going to be sentenced to 10 days in the county jail. He can be released upon the payment of $400, but he won't be able to be released until at least Friday, though.
Okay. And Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Prager, did you hear that agreement on the Jackson County charge, sir?
So come Friday, I can pay the 400 and get out?
Possibly even before then. So let's say that Mr. Mitchell talks to the Alabama District Attorney's Office today and they tell him, hey, since it's a misdemeanor and driving offense, we're not going to be seeking to revoke his bond. Or they tell him it's going to take a lot longer than 10 days to get the bond revoked. If they tell him that, I'm going to see you again tomorrow. I'm going to release the Alabama hold and you could pay it tomorrow and be released. But I'm going to give Alabama time to do it because the new charge is so serious and it's so recent. Any other questions?
And the only reason why I was trying to say something is because my lawyer, he went to the preliminary hearing, and from what he has informed me of, they are thinking about dropping the charges.
If that happens, I'm going to release the hold, obviously. So let's say that happens. If that happens, I'm going to release that hold immediately. Okay.
Okay.
Mr.
And then on
Mr.
top of
Prager,
that,
Mr. Prager, who is your attorney in Dothan? Who's your attorney?
Kato Carter.
Caleb.
No, I don't know who that is.
Caleb who?
Cater.
Are you saying
Cato
Caleb?
Carter.
Spell the first name, please. Spell it.
C-A-D-A Carter.
Oh, wait, I may actually have the number.
Okay.
It's
All
an
right. So
older
in
gentleman.
regards to the Jackson County plea, do you have any questions about that plea?
No, besides the fact that I was confused because I had been pulled over once and got told they was suspended, and then got pulled over by
John.
Alabama State Trooper, and they didn't say nothing about them being suspended.
Okay.
So I was honestly confused with the whole thing, and on top of that, I was not read my rights whenever I got pulled over and got put in cuffs.
Yeah. So you don't have to reread your rights unless it's an in-custody interrogation. But if you want to take this plea, that's fine. If you don't, I'm going to set your bond in Jackson County. I'm still going to hold you the 10 days. What do you want to do?
I'll just I'll wait until y'all find out what's going on with Alabama. So
Okay.
I'll do Friday.
All right,
I'll post bond Friday.
All right. Since you already own or have charges pending, your bond in Jackson County is going to be $5,000 cash or surety with a condition not to drive a motor vehicle unless you have a valid license. And I'll see you on Friday or before. Any questions?
No, sir.
Have a good day, sir.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. So there's a couple of questions in the chat about the Care Bear that's tagged. Hello, Ellie. Good morning. So look behind me, and you'll see the various things that I have on the set today. Many of those are tagged in the video as items that you can go and purchase. And will we make a commission off of that? If you do, yes, we will. But the reason why I've done this is I've gotten countless comments and chat messages and emails and whatnot asking me about the stuff on the shelf behind me and where they could get it and things like that. So I decided to put that stuff out there as a service because so many people have asked about it. If you buy something, you buy us a cup of coffee in doing it. If you don't, that's cool too, but it's just there in case you are interested in some of the stuff that's behind me. So with all of that being said, I'm not going to go there at the moment, but this is Judge Simpson this morning, so he's already struggling. So he's having a Monday. Let's go back to Judge Mercer.
I need another turn.
Have a good day.
Thank you.
Christian Foster. Mr. Foster, good morning. Mr. Foster, you're here for first appearance accused of 3 counts of battery. Mr. Foster, there is probable cause for those charges. I looked at your criminal history, which shows nothing. Corporal, I have a question.
You know my nana.
So, Say
You know who
again?
I am. I said, you know me. I was not hoping to see you this way, but you know me.
Yeah, I know exactly who you are, Christian. So Corporal, here's the question. He's charged with 3 battery counts. His rap sheet, the only thing it shows is a battery by strangulation from yesterday. What that tells me is somebody put in the charge wrong.
That's what I
And
was
I'm
trying to
concerned
tell
about
him
that.
this
So
morning.
my question, let me, Mr. Foster, I'm talking to the jailer.
Yes,
Just
sir.
give us a second. So Corporal, is that put in by the arresting agency or is that put in by the jail?
Agency.
That's put in by the booking officer, and the correction order will be put in today to reflect that. It just has to be a
Thank you.
correction order sent to FDLE, but it'll be done today.
Thank you. And I don't know how it happened. The statute numbers are correct on the Sheriff's Department paperwork. It had happened after that somehow. So Mr. Foster, your rap sheet shows that you've been charged with a felony. That's not correct at all. You're accused of 3 misdemeanors. So there is probable cause for the 3 misdemeanors. And Mr. McDaniel, just a bond analysis in this case?
Yeah, we just asked the court to consider conditional release. But
Well, I don't know that he has anywhere to live. Mr. Foster, you have no prior history, but the one alleged victim's your mother, the other one's your significant
Yeah,
other.
Yeah, I
Do
was.
you have somewhere else you could live on a temporary basis other than where they're at?
Yes, sir. Amanda Coker's, my nana. I can live there or I can live with my dad. I have plenty of places to live, sir.
Okay. Your dad doesn't live, is your dad Kelly?
Yeah, my dad stays at Cliff and Amanda's house until it's being sold. He was living with Cliff Coker, my nana's
But
ex-husband.
then your mother and your significant other, they reside in the same home, is that correct?
Yeah. Okay, so my
On Caleb Way?
newborn was, yes, sir.
Okay,
She lives with
so
my
here's what I'm
mom.
gonna do. I'm gonna let you pick between the bond. Well, let me hear from the state first. Mr. Mitchell, anything?
No, Your Honor.
I'm gonna let you pick between the bond and the conditional release because your history is so good. If you want to post the bond, it's $2,500 on each count. If you want to accept the conditional release, I'm gonna grant you a conditional release, provided that you have a verifiable place to live before he's brought up. So Corporal, what we need to do is let him call his dad or I think he called it his Nana.
Yeah, my
Coker.
nana Amanda.
And if either of them say he can live there, Corporal, I'm fine with the conditional release. But there's gonna be a condition, no contact with the 3 individuals who are alleged victims of the battery and no contact with their residence. There's no contact with Miss Foster, no contact with your brother, the minor, and then the 3rd person would be no contact with Miss Stewart.
Now, may I ask one question?
Sure you can, but don't talk
I
about your
have-
charges. Sure. What's
Yes,
your
sir.
question?
I have no problem with that, but for how long? Like I said, my newborn was just born 7 weeks ago, so
Okay,
will I be able to
let-
see him?
Let me clarify. The newborn is not the minor that's the alleged victim. That's a different minor, obviously. So I'm not putting a condition, no contact with your child. I'm putting a condition, no contact with your brother, the mother of your newborn child, and your own mother. So what that means is if some 3rd party works out contact, if, for instance, your dad works out a visitation with your newborn child, I have no problem with that. I'm just keeping you away from the child's mother, your little brother, as well as your mom. Any other
Yes, sir.
questions?
No, sir.
And you want to accept the conditional release or do you want to post the bond?
The conditional, I don't know what's the difference?
Okay.
that's what I explained to you, Eric, when you asked me what's the difference.
Conditional release means you're under court supervision. You got more rules to follow. Bonds, you got to put up money to get out of jail.
Okay, yeah, I'll do the conditional release.
I'm gonna grant you conditional release, provided you have a place to live. So Mr. Gibson, if y'all verify that, or if the jail verifies it, then I'm fine with that. Otherwise, he's got the bond set of $7,500 total. No contact with any of the alleged victims. Mr. Foster, wish you the best, sir.
Yes, sir, thank you.
Yes, sir. Michael Pryor.
Your Honor, we turned him to the cell. He didn't want to flee.
Okay, Mr. Pryor's already got a bond set by the weekend judge. There's no plea agreement reached. That brings us to Jacob Smith. Mr. Smith was arrested this weekend, charged with 1 count of possession, drug paraphernalia, and 1 count of knowingly attaching registration. It's improper. It's knowingly attaching tag, correct? Attaching tag not assigned as actual statute. So, Mr. Smith, a judge found probable cause this weekend. You were brought back up to try to speak with an attorney and see if we could try to resolve the case. I'm going to appoint the public defender's officer to represent you and ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke with Mr. Smith. He's going to plead no contest to the charges as listed. You understanding he'll be sentenced to 11 months, 29 days probation on the possession of drug paraphernalia. We $370 fine, or actually it'd just be a $400 fine. Is that correct, Donald? Yeah, it'd be a $400 fine. And on the knowingly attached registration, knowingly attaching the tag not assigned, there'll be 6 months probation. It all run concurrent though. So in actuality, he has 1 year probation. You only terminate after 6 months, $400 fine. He has signed his plea waiver form, waive his right to jury trial and call witnesses. $370 fine then.
And Mr. Mitchell, is that agreeable with the state?
I think so. Yes, sir.
And Mr. Smith, did you hear that agreement?
Yes, sir.
Have any questions about that agreement?
No, sir.
Sir, is that the plea you would like to enter to resolve these 2 charges?
Yes, sir. Yeah, I got a dad I got to take care of and stuff at home, so.
All right, Mr. Smith, I'm going to accept your plea of no contest of those 2 charges, possession of drug paraphernalia and attaching an improper tag to a vehicle. I'm going to withhold adjudication of guilt on both cases, sentence you to 11 months and 29 days probation on the first degree misdemeanor. That's the drug paraphernalia charge, 6 months probation concurrent on the second degree misdemeanor attaching tag not assigned. I'm going to impose a standard court costs and fines in the possession of drug paraphernalia, which is $370. I'm going to waive the court costs and fines in count 2. I already said they were concurrent, 370, I already said that. So Mr. Smith, what's going to happen next is they're going to let you get dressed in your regular clothes. Then they're going to bring you to the courthouse because the probation office is at the courthouse. When you get here, the probation officer, Mr. Goodson or Mr. Ham, one of those will go over your probation with you. They'll give you a chance to ask any questions. They'll give you all the rules in writing and you'll be free to go. Mr. Smith, if you use the phone before you leave the jail to call friends or family for transportation, tell them you can be picked up at the courthouse in about 30 or 45 minutes. Lastly, it's possible for you to get off probation early. In your case, that would be possibly at 6 months. The way you do that is you have no violations, you get everything done. So try to get everything done early, and it's very, very likely you're gonna get off probation at the 6 month point or whenever you can get everything done if you have no violations. Mr. Smith, any questions?
That's it.
All right, sir, I wish you the best.
All right, appreciate it.
Yes, sir. Corporal Jones, is that it for jail first appearances?
Yes, sir. I just have one question. What was the bond again on Mr. Foster's? I didn't write it down. I missed it somehow.
$2,500 times 3.
Yes, sir. That's all I need to know.
Corporal, we had some people come in the courtroom and we've done first appearances. We started at 8:30. So if you tell me what case you're here on, I can tell you what happened.
I'm sorry, I missed it.
It's okay. So he's got a $2,500 bond on each of his 3 cases, but he was offered a conditional release because it has no prior history. He has a condition of no contact with any of the 3 alleged victims at this point. That'd be you, I guess your other son, and then the mother of his child. His conditional release is conditioned upon him having a place to live. He says he thinks he can go live with Miss Coker or where his dad's at. But I told him I'd grant him the conditional release, but that's got to be verified that he can live there. So as long as he has somewhere to go, he'll get out of jail today. He can have no contact with the 3 of you. There is not a no contact condition with a newborn child. So if they work something out on that, when I say they, I mean the mother and he can't talk to the mother, but if you, or not you, he can't talk to you either. But if his dad works out something for him to see his child, that's fine. I'm not keeping him away from the child. I have no basis to do so, just the other individuals. Do you have any questions?
I mean, what's next? I've never done this before. Will we go to court?
He'll have a court date. As a matter of fact, let's give him a court date when he comes to the conditional release office. Mr. Mitchell, what's the arraignment date would be appropriate?
Let me double check. 25th.
He'll get a notice for August 25th. That'll be his court date. If all 3 of you won't, or any of the 3 of you won't contact, you can fill out a form at the probation office, which is where the conditional release office is at downstairs. And I'll review it and consider it. But right now there's no contact because that's essentially what we have to do when the victim's not here. Do you have any other questions? All right. Thank you for coming. Anyone else that's came in the courtroom on the first appearance case in the back? Yes, ma'am. Who? Okay, that's not on our docket here. Let me see if it's one that didn't come back up. No, we don't have a Moss. Is that, what kind of case is it? You got to give me a little more information. You don't just.
Somebody was tired last night.
Is that person in jail? Is it a criminal charge or civil?
Civil. No, I think probably violation of probation.
Okay, that's criminal, but let's try to see what we can find out. MOSS?
Yes.
How you spell the other first name?
Zeffrey. It goes by Lane.
Did somebody tell you he was going to be in court today, ma'am?
Yes.
Who told you?
Well, I heard through the grapevine, not reliable necessarily.
Let me ask you this question. You're saying Moss, MOSS,
Right.
first name Zeffrey, Z as in zebra,
Yes.
EFFREY.
Yes.
We don't show a pending criminal charge on a Zeffrey Moss in Jackson County, so I can't help you. I have no idea.
Thank you so much.
Yes, ma'am. Hey, let me check one more thing, ma'am. Before you go, let's check the Florida Department of Corrections website.
He does have an active warrant out in 23625 CF here in this county.
Corporal Jones. Any chance y'all got a Zeffrey Moss that got booked after the cutoff or before the cutoff? Yeah, after the cutoff. Zeffrey Moss with a Z.
Not that I'm aware of, but I can check real quick who's waiting to be booked. There's one still waiting, and they booked in about 3 this morning when we got here. So give me just a
we
moment.
have a
I'll
lady
look.
here in the courtroom. If you can check, we'd appreciate it.
It's very
Yes, sir.
likely he could be in Liberty County Jail because he has an open Liberty County misdemeanor charge of paraphernalia and resisting without violence. And you did say we are covering Calhoun, so it's possible.
They didn't have any today.
Yeah, he probably wasn't booked in time for today. I don't know. Speculating.
We're just gonna find out if he's in our jail.
Thank you.
The next step may be Liberty County. He may be housed in a different jail.
No, sir, he was not booked in the jail.
Sorry, ma'am. Can't give you more information. Yes, ma'am. All right, so we do have State of Florida versus Christopher LaShawn Smith. Mr. Smith, come on up. This is case 25-293 CT. Mr. Smith found out about a court date that he missed, but I think that he's shown some documentation to the state. Gary, we give that to Mr. Smith and Mr. Mitchell.
Yes, Your Honor. He's shown valid documentation of a valid driver's license, so the state will announce a dismissal in his case.
Okay, so Mr. Smith, the state's going to be dismissing the case because you've been able to get your driver's license issue resolved. So that'll get filed and that'll automatically result in a dismissal of the warrant. We just set aside the warrant in this case so it doesn't get picked up. You give him a notice just saying that or what? That's a good idea because if you get stopped for speeding 20 minutes from now, that warrant's still going to be in the system.
Yes.
So this piece of paper, you can show them you were in court and you got it took care of. Any
Yeah,
questions?
Yeah, one question. The DOT officer told me, told me whenever I got the ticket that I could contest it if I wanted to.
This ticket,
Yeah,
do you want to contest it?
yes, because I had everything.
So
I just.
Mr. Mitchell's dismissing it.
Okay,
So if you contest it and you win, it gets dismissed. So he's dismissing, you basically contested it and you brought the proof, so he's satisfied. The prosecutor's going to dismiss it today.
okay. Well, as far as with the DOT, what will I need to turn in something to Tallahassee or? Well, I won't have
There
to,
shouldn't be any
because they gave me a ticket
consequences
for it,
unless
too.
did you get was the ticket you got the exact same thing that you're here for court today, or did you get another ticket? A civil infraction?
Well, I got some DOT tickets and one of them was, driving with a suspended license, which was $100.
Civil tickets from DOT are handled in administrative, where they're different.
It depends if it's a FDOT ticket or a state ticket.
Did you bring the ticket with you?
No, man. Right there.
Let me see if there's anything in Jackson County Court pending other than this. I need that case number known.
Yeah, it should. I don't need to print it. Just as long as it's filed.
There's a 2022 civil infraction pending. Let's see if that's it. That's a common name. Not the middle name, but your first and last name is pretty common. You got any other charges pending that you're aware of in Jackson County? I'm not seeing anything else. There's an old stop sign, but that may be different. Christopher L. Smith. What's your date of birth?
1973.
Different person. I'm not showing anything else pending in county court in Jackson County. So what that means is Mr. McDaniel's probably right. They may have issued you federal tickets, which you got to take care of through federal DOT. They're not something we can deal with in state court.
All right.
All right.
Yeah, I've been calling it ever since I got the tickets to contest it, but I can't never get through to them. I have to keep
Check
trying.
with them and make sure that the number that you have is the same number that it's on.
Yes.
Take care, Mr. Smith.
Thank you.
And Your Honor, I just filed that no info. So
Thank you.
it's been dismissed officially.
Mr. Mitchell, anything else on first appearance purposes?
You did ask for a proposed order revoking bond for Crystal Carnley. Do you need one for Demetrius Batson also? His bond was revoked over the weekend.
I didn't do that. Whatever judge did that needs that one, not me.
Okay. It'd be Judge Taylor, I think. So
Yeah.
I'll let ASA Cook know.
Thank you. Mr. McDaniel, anything? No, Your Honor. All right, ladies and gentlemen, that concludes first appearance.
Okay, so Ashley in the comments has expressed a fear of being pricked with a cactus. Ashley, cactus is a lot like quicksand. You grow up thinking through cartoons and stuff that it's going to be like a big deal in your life, but it's never actually a big deal. Same thing. Cactus, as Michael pointed out, you have to go out of your way to be pricked by one. So not a thing, just like quicksand. Let's go to Sego County, Michigan. This is Judge Mertz. I've featured him in a couple of long-form videos on the channel, but never on the live. But I think justice is best served in a renovated pole barn. In Ohio, in southern Ohio, they think it's a dungeon. Here, they think it's a pole barn. So let's see what's up here.
Pay a fine. So it wasn't set up to go into the office. It was just to make sure I was paying my fine.
Okay, where was that out of?
In Gaylord, Oxebo County.
Okay. Are you aware of that, Mr. True?
Was that to the circuit court or the district court, Mr. Musa?
This district court.
And are you still on probation to them?
I never really was. I was just told to pay my fine. That's what I was doing.
Have you paid those fines up, or do you still owe that money to district court?
I still owe the money.
Okay. All right. I'm not sure if that means that you're currently on probation there, or if you're just on, some type of payment plan. So do you report to like a probation agent at the district court?
No.
Okay.
I was on a payment plan. That's what was set up.
Okay, gotcha. All right. So in this case, you're going to be pleading guilty to one count of resisting or obstructing as a habitual second offense. That means that the maximum possible penalty that you could face for that charge would be up to 3.5 years. Do you understand that?
Yes, I do, Your Honor.
And then, as we were discussing here, the maximum possible penalty that you could face for domestic violence third offense as a second habitual offender is up to 7.5 years. Do you understand that?
I do, Your Honor.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
It's I'm in a ministry now, and I've been doing so good, and I just feel like I'm forced to lie, but I guess say I'm guilty.
Okay, well, you just took an oath to tell the truth.
Yeah.
So, if you're telling me after taking that oath that you're now going to deliberately lie, that's something that we can't really do here. So whatever we discuss from here on out, I need you to be clear that it needs to be the truth, okay?
Okay. I am guilty for RNO for not obeying an order. And I am guilty for pushing my girlfriend. So I guess I would say that would be abuse.
Okay. All right, so I'm going to go through your rights with you. Right now, you have the right. You have the right to have, and one thing I should mention too, Mr. Musel, because we're doing this remotely. If at any point you can't hear what I'm saying or you need me to repeat something, just raise your hand or let me know, and I'll make sure that I do that because I want to make sure that you hear and understand everything that we're doing. Okay.
I will do, Your Honor.
Okay. So I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. Do you understand that you have all of those rights?
I do, Your Honor.
And you understand that by pleading guilty under this plea agreement, that you would be giving up and waiving all of those rights and you would not have those anymore.
Yes, I do, Your Honor.
Okay. Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave, and that means that you would have to ask the Court of Appeals to hear your case. If they said no, then that would be the end of that appeal. Do you understand that?
Yes, I do, Your Honor.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anybody promised you anything other than what we've talked about here on the record today?
I thought that the habitual was dropped completely, but other than that, no.
Okay. You understand that as part of this agreement, it's not dropped completely, right?
Yeah, now I do, yes.
Okay. Is it your own free choice to enter into this plea today?
It is, Your Honor.
And then I think you've already said this, but again, you've indicated that you're pleading guilty because you are guilty of the resisting or obstructing, correct?
Yes, I failed to follow an order, but I did not use physical violence in any way.
Okay. All right. And then you said that you are guilty of the domestic violence for pushing that individual, and we're going to talk about that a little bit more in detail. Is that correct?
That is correct. I was defending myself. I should not have pushed her, so I did cause harm to her. Yes.
All right. So the date that I have for this incident is back on January 11th. Is that correct?
That is correct, Your Honor.
Okay. And was that like in the nighttime, maybe around midnight of January 10th or January 11th?
It was in the evening. It was more like around 8, 9.
Okay. And at that time, were you here in Otsego County when this incident happened?
Yes, I was, Your Honor.
All right. And you mentioned your girlfriend. that's somebody that you had a dating relationship with, or some other type of domestic relationship, is that correct?
We were engaged and I was living with her.
Okay, and is that where you were living together? Is that where this incident happened?
Yes, it is, Your Honor.
Okay. So, Mr. Trush, I don't know the circumstances, obviously. Maybe you can flesh that out.
Sure. So on that date, did you and your girlfriend Tara have an argument?
Yes.
Did that argument turn physical?
Yes.
And did that result in you pushing her?
Yes, it did.
After that, did the police show up?
Yes, they did.
And you knew that who you were interacting with was the police on that date?
Yes.
When you interacted with the police, did you tell them that you were armed?
No, I actually said, if I have a gun, then shoot me, because I did not have a gun on me. And I suffer from major depression. I just wanted to die that night.
When you interacted with them, did they give you commands that they were placing you under arrest?
No, not at that time. I came out and I willingly, and we walked to the patrol car, and then they had said we are investigating, and we went back to my residence for them to investigate. And then later they had told me I was going to jail.
So you had indicated that they had given you some commands you didn't comply with. What command did they give you that you didn't comply with?
Throw the gun out. If you have a gun, throw it out. And I wasn't in the right state of mind. I said, if I have a gun, shoot me. Just shoot me.
Okay, so when they told you to throw the gun out, did you keep your hand in your pocket?
I do believe so. I did. And then I confirmed with them that I didn't have a gun. I went with them. There was no physical violence at all. So I obeyed the order.
So you said that they told you to throw the gun out. Were they trying to get you to show them that you weren't armed?
I do believe so. And I was hesitant about that because I just, like I said, I was so depressed and from PTSD from them. They just wanted to not be living anymore. But I'm so glad for that night to happen, because now I'm here. I have a purpose. I know that God wants me to be here. So
When they told you to do that, you didn't do it when they told you to do it, correct?
no, yeah, you were correct.
I think that would supply the basis for the RML.
All right. Is Mr. Trush, is there any dispute about Mr. Musil's prior record in terms of his domestic violence convictions that would make this a third, or is it habitual?
No, we would stipulate to the facts contained on the information.
Okay. All right. With that, Mr. Rolla, are the people satisfied with the factual basis?
Yes, Judge, specifically as to the RMO, that the officers is now acknowledged by the defendant, told him to take his hand out of his pocket, and he refused to do so. I think that was sufficient under the statute with the other information the court has. The only question people have is where he was actually at when they told him to take his hand out of his pocket. We had the start of the incident, not necessarily the end of the incident.
Yeah, Mr. Musil, this all occurred, including your interaction with police, that that occurred at the house that you were living at in Otsego County?
Yes, I was on our property. I ran across the lake, but I was just trying to find my fishing hole to jump in, but I didn't find it. But yes, I was there.
Okay.
With that clarification, are the people satisfied with sufficient factual basis to accept defendant's guilty pleas to count 2 as well as adding count 4?
Okay, Mr. Rolla, or I'm sorry, Mr. Trush, are you satisfied with the factual basis?
Yeah, sure.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Judge.
Mr. Trush?
Defense is satisfied.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Trush?
I'm satisfied.
Thank you. Mr. Musel, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea. This matter will be set for a sentencing hearing. You'll be notified of the date and time of that hearing. It's going to be in about 30 days. So, Mr. Musel, are you still going to be at that facility where you're at?
I will be, Your Honor.
All right, Mr. Trush, does he have the ability to come here for sentencing, or do you know what the circumstances are?
I guess what I would indicate to the court, I think it's clear his preference would be to do it via Zoom. I suspect that we can arrange transportation if we need to.
I mean, do you know what the guidelines are here?
I do. The guidelines are going to be on a prison sanction.
Okay, so Mr. Musel, you need to you're going to need to be here in person for sentencing on that date. So, Mr. Trush, it sounds like you can work with him to.
And I can work with the ministry to arrange whatever we need to do.
So your attorney's going to help you with that. And between now and then, Mr. Musel, somebody from the probation department will be in touch with you for a pre-sentence report. So just make sure that you follow up with them when they contact you. And of course, just make sure you stay in touch with your attorney, okay?
I will do. Thank you, Your Honor.
All right, thank you. And then in light of the plea, the court will adjourn the trial dates currently scheduled. And that's all we have for today. Thank you, Mr. Musel. You're free to disconnect at this time.
Thank you.
Okay, a couple of things real quick. First, Michael said, Dan, I like your artwork for these courts judges, but this one should have a cow in the background. I disagree. If I put anything in the background, Michael, I think it should be the Michigan militia. This is Otsego County. The county seat is Gaylord. That's very up in the northern part of the Lower Peninsula there, and a popular hangout spot for the Michigan militia. So that's what I would put in the background if I was going to change it. Another thing that was brought up in the comments was Ashley saying that domestic violence but no actual violence was what was being talked about. This doesn't directly relate to what happened in that case, but it got me looking things up, and I asked the question, can you have a domestic violence charge without actual physical violence? And the answer in many jurisdictions is yes. Emotional and psychological abuse such as intimidation, threats, manipulation, gaslighting, verbal degradation, they count. Coercive control like isolation, monitoring people's movements, controlling their access to money. Economic abuse like preventing a partner from working, controlling their finances, or sabotaging their employment. Hello, Ellie. Technological abuse like stalking via GPS or phones or social media count. Misusing the legal system like filing false reports, that counts. Get your butt out of the camera, silly. So there are other things that actually count as domestic violence that are not necessarily violent acts in and of themselves. So I just thought I'd share that because it's interesting and it's good to know things. Let's go to Louisiana. Michael, get your vote in now.
Yes. Madam Chair, we have a quorum. All right, we have 4 members present today. We do have 1 member absent, so any favorable action will require unanimous vote of those present today. Our first item of regular business this morning is review and approval of the minutes from Monday, July 7th, which were included in your packet. Are there any corrections? Having none, seeing none, I'd entertain a motion for approval.
I'll recommend that we approve the minutes.
We have a motion by Mrs. Stapleton, second by Mr. Prater to approve the minutes. Is there any objection? Hearing none, the minutes are approved. We will allow public comment on requests before any action item. And so our next regular business item is consideration of applications for clemency or pardon. And we have our first case this morning. Sir, would you introduce yourself? Tell us your name and current mailing address.
Yes, ma'am. My name is Wilson Trimble Mabry. I live at 2020 Island Drive, Monroe, Louisiana, 71201.
Thank you, sir. Welcome. Let me acknowledge your guests. The fact you have with you have your wife, Ms. Talbot Mabry, your pastor, James Doherty, your attorney, George Campbell, Harry McSherry, your uncle, and Patricia Stroop, your friend. And we have your pastor and your uncle will be speaking on your behalf at the appropriate time. We'll call on them to do so. And I understand your attorney is here if we have any questions. Do you have a presentation?
I don't.
Okay. All right. So let me just read some identifying information, sir, into the record. So, Mr. Mabry, you're classified as a first felony offender. You're seeking today a pardon with restoration of firearms. You were sentenced in July 2009 in the 4th Judicial District for simple escape and aggravated escape. Sentencing was deferred and you were placed on a 3-year probation term. Is that information correct, sir?
I believe so, yes.
Okay. So tell us, sir, why, before we start our interview with you, we'd like for you to tell us why you're seeking a pardon with restoration of firearms. How'd you get in trouble and why are you seeking relief?
So I got in trouble. Is that what you're at? How did I get in trouble?
Yeah. What led you there?
So, I just want to tell you who I am and tell you the truth. Before I committed this crime, I was very selfish and I was arrogant and prideful. And I was an alcoholic. I was a drug addict. And I was just living in darkness. But also I was lonely and scared and had anxiety and was living in shame and guilt. And I found myself in the back of a cop car and I thought that my life was over. I truly did. And I had a wave of fear come over me and I made a snap-second decision. And all I could think to do was run. Just run away. I was like a scared little child. And I did so. And it was one of the worst decisions I've ever made. But I have redemption because of that decision. And I used to regret it. But as I look back on it and I look back at my life and I see the things that Jesus has done in my life, I don't regret it anymore. And, the night I committed that crime, I'm so grateful that I met God. I was able to hear his voice and hear him speak to me. And it wasn't a voice of condemnation or anger. It was very kind and merciful. And he asked me if I had just had enough. And I simply said, yes, I have. And I made a decision at that point to follow him and to do what he instructed me to do. And he led me to Jesus Christ and the love there and the mercy and the grace. And I've been totally redeemed. And I'm just so grateful for it. And I received a spiritual pardon, not because of anything I did. I didn't do anything to earn it. It was given to me through faith because I believe in Jesus Christ and what he did at the cross counted for me. And that's enough. So spiritually, I've been pardoned. And now I'm just seeking a physical pardon. I would like my rights restored. I want to spend time with my children in the outdoors. do the things my father did with me. It's been a journey. But I'm grateful to be here, and I'm so grateful that God saved me. I don't know what else to say.
Okay. Well, your case has been assigned to Mrs. Stapleton. She'll have some questions for you.
Let me get this stuff together here. Mr. Mabry, I've read your case very thoroughly. It seems like you were a boy when you started with drugs. Am I correct?
Yes, ma'am.
You were a young boy. Did you come from a wealthy family at that time?
Everything's relative, but I would say yes. My parents were divorced. I don't know any different. And I would consider my father wealthy. And I would consider my mother not extremely wealthy, but we lived a wonderful life.
Yeah, because I see where you started with alcohol, then you moved on to marijuana and pain pills, and you were just a young teenager at the time. And then by the time you were 16, it was cocaine and ecstasy.
That's correct.
So, but you did wonderful in school.
Yes, ma'am.
I mean, an honor student, and nobody would have guessed that was going on in your life, really. Did your parents have any idea? Was there anything going on that maybe clued them in, or was it just so well hidden?
I think it was a combination of both. I talk about, I've given a testimony many times about my walk with Jesus. And, part of my genetic makeup, the way God kind of shaped me is, I can take on any identity that I need to take on to, make people accept me. And so I was very good at putting on, a well-mannered, goody two-shoes type. I could do that, but then I also noticed when I was a different way, someone that broke the rules, so to speak, some peers would like that as well. So I kind of did both of those because my goal was just to make everyone to like me. I suffered from, I just wanted to people please. And it wasn't a good thing. That's just the way I was. But because of that, I was able to hide my poor qualities, my unlawful qualities around people of authority. And I was very smart. I was blessed by the Lord to do well in school. And that just kind of goes with the culture of, oh, well, he's doing good in school. He must be being a good person. And that just wasn't the case for me. That's what's been so great about my relationship with the Lord is I don't have to worry about what identity I am anymore because I know that I identify as a child of God. And that alone is good enough for me. So I don't have to do anything else to put on a show for someone or gain their approval. The Lord already approves me and accepts me because of my belief in Christ. And that's all I needed. I wish I would have known that.
I get it. I get it. Okay. I really
Took a
do.
little while.
Well, that's the thing about having a broken, retentive heart. You know that you could have done it at any time, but something happens, and then you go to the Lord and you ask Him to be there for you, and He is. And then at that point on, your walk with Christ is real in exchange for that very instant in your life. So I do understand that.
And it worked for me so well. I tried so long to do better and pull my bootstraps up, and it never worked. It wasn't until the Lord did it for me and changed me from the inside out that I began to see long-term responses.
Okay, so how old were you when you were arrested? Because I know we're talking about 2009, your life changed. You were 22 at that time?
Yes.
And so you finished and got your engineering degree?
Yes, ma'am, sure.
Okay, and so from that point on, then we move forward into the rest of your life, which is where we are today. And I saw videos, saw the little children. I love my daddy. And everything that you've done in your community and things like that. And nothing further. I mean, you went to rehab and boom, so I don't have any further questions. And I commend the change that you made in your life and the reason why.
Right.
Anybody else?
So let's hear then from your pastor, Mr. Doty. Would you want to speak? Go ahead, sir. Yeah, you step up to the podium, please.
Hey, I'm James Doty, and I'm Wilson and Tally's pastor. I've never been to one of these before. This is my first time, and I was driving down yesterday, and the question that kind of kept coming to my mind was, can people really change? I'm sure y'all hear a lot of stories, hear a lot of people, and that fundamental question of like, can people really change? I was thinking of it's in Jeremiah 20:13-23. And I think the Bible poses the same question. It says, can an Ethiopian change its skin? Can a leopard change its spots? And the answer to that is no. The leopard can't change its spots, right? I mean, it's who he is. But one of the things that I love about scripture, and Wilson already alluded to it, is that when you turn to the Gospels of Christ, one of the things that he says is that we can change. But it's not just behavioral change, it's this deep spiritual change, and that's the hope of the gospel. Is that Jesus Christ, because of his life, his death, his resurrection, that faith in him can actually fundamentally change, not just behaviors, but fundamentally who we are. What's in 2 Corinthians 5:17? Anyone who is in Christ is a new creation. I always think, y'all probably have your phones. You get kind of like you get those software updates that just it just tweaks it a little bit. But what Christ offers is not just a tweak, a subtle upgrade. It's a fundamental change of who we are. Through getting to know Wilson and Tally, one of the things that I've observed and hear in his heart, knowing him personally, is that he has been fundamentally changed by Christ. I think you hear his testimonies. I think you've heard it probably in all these things that he has fundamentally been changed. Who he was then is not who he is now. Now, he's not perfect. Tally could probably testify to that. I don't know if y'all want to hear from Tally, but she probably could testify he's not perfect. But he has been changed. He leads men in our church. He teaches Bible study. He is a pillar in our community. And I'm grateful for them, for their family, for the kids that are at our church. And I've seen the change that's taking place. So my recommendation for y'all would be that you would extend a part to. I'm grateful. Thank y'all for hearing us. And I'm grateful that Wilson my friend.
Sir. Mr. McSherry?
In spite of being a former federal prosecutor, I suffer from stage 3 stage fright. I'm short of these guys. I sent a letter in, which sort of summarized, but I also took a little shot at the law. Because as I said, I sort of take a little bit of responsibility after 43 years in prosecuting a lot of felon possession cases that the law is such a mess right now in terms of what you can do and what you can't do. And I've had thousands of people over those years come to me and said, I want to have my federal rights restored. What I need to do. And it was so wonderful because I say, well, go to the state. Go to the state. But that wasn't the answer at all. Because the state doesn't have a clue of what we in the federal system really require. So we say you need to restore your full rights, your full civil rights, and then you're free to go. And there was a time I remember when you could go into the ATM and they'd give you a little certificate, sort of like a badge of courage, that you could put on your wall that said, we listened and reviewed, and his rights, say bear firearms under the federal law, have been restored. That's gone out of the way. So I'm just here to apologize to Wilson. I went to Wilson and I said this. I said, Wilson said, we just need one case in federal court where someone who's had an 893 dismissal of a non-violent, non-drug, non-sexual related felony has had the full expungement under the 2016 amendment. And way more than 10 years have passed since that conviction and completing your probation. We need one test case. So would you be willing to do that? I said, you take a firearm and I can get you charged and we can go to court. I think that if you charge, a federal judge will throw it out. You know what Wilson said? I'm gonna go to the park. That's all I can do. But he is the best candidate. No, I've stood up and I have opposed pardons most of my life. I'm down here and opposed pardons most of my life. I'm ashamed of it, but listening to the people outside, it's really sad, really hard. But I ask you to give total consideration. He was a spoiled little kid, but so was I. And when I became an assistant U.S. attorney, someone came to me and said, you know what, you've given a lot of people hope. I said, what? They said, somebody as bad as you who could pass the FBI background check. So I'm here to support Wilson. And the other reason I'm here is I went to my cancer doctor, I had cancer 13 years ago when it was returned. And I asked the doctor, what do you think, Doc? What's my diagnosis? He said, well, I think there's some treatment for you, but he said, I think I would sick a party. So that's what I did. Y'all help me with that. Thank you, appreciate it.
Thank you. Yes, sir. Okay. All right, thank you. So Mr. Wilson, you want to step back up, sir? I don't see any other questions, so I think we're ready to vote.
I got a question.
All right, Mr. Tiller.
You say you're a drug addict?
Yes, sir. Historically, I was, yes.
Did you take any treatment?
Absolutely.
You did? What?
I went to Palmetto Rehabilitation Center for 90 days and underwent just their systematic. They have a 12-step program. They also have counseling that they provide. It's inpatient. And then I'll just continue to, it's interesting. The 12-step program, I noticed as I went through that program in Palmetto, it also lines up with the pillars of what Jesus teaches as well. And so I've been able to kind of live out those 12 steps through my following of Christ. And it's just continued to provide me with the stability I need to continue to live a sober life. But I'll be honest, I don't consider myself a drug addict anymore because of the biblical 2 Corinthians 5:17. The old is gone and the new has arrived. I'm a new creation in Christ. And I don't call myself a drug addict anymore. I don't know if that necessarily lines up with the 12-step programs. I do know that I can never have any involvement with any narcotics or alcohol. It's just something that the Lord has said, this is not for you, and be obedient to me and don't do those things. So I don't do it.
When did you take that program?
That is immediately after I was arrested. So I was 22 years old.
So you haven't been to any other programs, like normally alcoholic, always the alcoholic. Most people go in classes.
So I go to Bible study. I also, again, I follow the 12-step program, maybe not through that particular 12 steps, but through my Christian walk, I'm able to, answer the bell, if you will, of the 12-step program. Make sure I don't hold resentment. I take myself accountable. I do go to a faith-based Christian counseling at the Banner Institute from time to time just to work on my mental health. But I am not actively in Alcoholics Anonymous at the moment. No. I'm not gonna lie to you.
So you just feel like you can walk away from it just like that and you don't need any more help?
Well, I believe that I actually receive lots of help in my biblical Bible studies with other men. A lot of them are actually sober themselves. I don't know, it's not something that I struggle with. I don't have the urge to drink. I don't have the urge to use drugs. It is a supernatural phenomenon. I don't know, I think it's 17 years of sobriety, but I don't take it for granted. And I don't, I have to always remember to remain humble and remember who I was before that I met Jesus, and to know how weak that I am in my own right, and that it is the power of the Holy Spirit that gives me the strength to resist the temptation of alcohol and drugs, but not only that, to resist the temptation of envy, anger, lust, all the sins that I could potentially struggle with. I must rely on the power of the Holy Spirit to keep me away from those things. It is not by my own merit and my own might, but it is by the power of Christ that lives in me. For it is no longer I who live, it is He who lives in me. So again, it is a posture of humility to understand and not forget who I was, but I'm not going to live there because that individual was dead. He was buried with Christ, and I have been raised in newness of life. And as I live in that newness of life, the Lord has called me into sobriety.
So you think a couple of years down the road, things got a little rough. You had a drink, maybe you thought maybe I'd get high again. You don't think you would get back into your old habits?
I do not, and I hope you understand when I say this. I'm not trying to cause any rifts, but say that in the future tense. Like if something gets rough, my life has been rough since this incident, since my sobriety, since meeting Christ. Following Jesus Christ does not make your life super awesome and great and unbelievable and everything goes right. I don't follow Jesus Christ because he makes my life awesome. I follow him because he is more awesome than life itself. I have had tons of turmoil. My father has recently passed away from an incredibly horrible disease, which he became manic and psychotic. But I was able to have him saved through that episode because of my faith. I continued to pour biblical truths into him. I combated his worldly thoughts with biblical truths, and I was able to watch him surrender his life to the Lordship of Jesus Christ. And I know that he is in heaven. And it is something that I prayed for years, that I would see him be surrendered. And that prayer was answered, but not in the way that I thought. I lost my father. It was horrific. But I never even considered turning to drugs and alcohol for some type of stability there, because there is none to be found there. My stability is based upon the foundation of my belief in Jesus Christ, and that's what I will continue to turn to. And I pray that I continue to turn to it until the day that I meet him in person.
Here's that, Mrs. Saban.
I am. Mr. May.
Before we.
Sorry, go ahead.
No.
Mr. Tillis, did you see where he, you asked me if he had anything rough, come up and he's farming 4,000, eh? So you know things have been tough on him sometimes.
With employees.
I've experienced financial crisis. I've experienced death. I've experienced sickness. I've experienced the things of this world. We can all attest to these things. This is a broken place we live in, but I will never give in because I stand in victory because of what Jesus Christ did at the cross.
I
don't. Mr. Mabry, you've had a completely clean record. It's been, and I understand that the Lord can touch a person, but it's going to be evidenced by your walk later. There's been no further problems, and you went to rehab right away. And so based upon that and your life since 2009, I would make a recommendation to the governor to give you a pardon with full restoration of files. Mr. Prater?
I concur with that recommendation, pardon, full restoration.
Mr. Tillis?
I concur.
My vote also is to recommend pardon with restoration of firearms based on the man you become. So we'll make that recommendation on your behalf, sir.
Approved? So I'm not going to discuss the denial or the approval there. It is what it is. As a man of faith, and I make no secret of that, I end every live show with "Take care, God bless." So it's pretty obvious. I have thoughts on his whole presentation that he gave, but I'm not going to hijack the entire live show to go into it, but I will hijack the pre-show. So tomorrow, 9:30 Eastern, 6:30 Pacific, tune in, and I'll give you all of my thoughts. If you're not already a channel member, go ahead and follow the link in the pinned chat and become one, and you can join tomorrow and hear what Dan really thinks, because I have thoughts. Michael said he wanted to see some bears eating some salmon. I don't have that queued up yet, but I'll see if I can get that for later. Let's do this. Let's go to Texas and Judge West.
Thank you, Mr. Smith. Let me get that pulled up. You got that. Thank you, sir. Good morning. Are you Darren Carter?
Yes, sir.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Carter, in cause number 25 DCCR 0778, the state has elected to proceed on the lesser included offense of a Class A misdemeanor resisting arrest from April 2nd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Turner? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And the agreement is for 30 days in the Jefferson County Jail, and it's my understanding, and they've asked me if I can hold sentencing while you also take care of a misdemeanor case between now and then. I want to make sure you understand some very important things if I do that. One is, if you don't show up to court, obviously you run the risk of me not accepting this plea agreement. It's off the table. We're back to a third-degree felony with priors. Also, if you are arrested for anything between now and when you come back for sentencing, I don't have to follow this agreement. You understand? And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Carter's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for about 3 weeks. That should give you time to get the other case taken care of. We'll come back and we'll have sentencing on that date. I don't need a pre-sentence report done. And again, just make sure you follow all those instructions between now and then.
The clerk suggested that you would give us that date.
She'll, 3 weeks is what?
August 11th, would that work?
Yeah, that's,
It's a Monday.
yes. Yeah.
Okay, perfect.
Okay, all right, we'll see you then.
Thank you. Thank you, Judge.
Thank you, sir. Mr. Parker, on Kennedy Webb. Good morning, sir. Good morning, ma'am. You're Kennedy Webb. And will your client waive the formal reading of the indictment?
Oh, Your Honor.
Ms. Webb, in cause number 25, DCCR 0258, you're charged with the state jail felony offense of a false alarm or report to emergency services from November 12th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 2-year deferred adjudicated probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, including not having contact with Tashelle McKinney and Lamar University. Do you understand? And do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, I understand.
Right, just to clarify, this is under section 1244A. It's
That's correct, Judge.
punishable as a misdemeanor.
That's right, Judge.
So is it state jail felony,
Just punishment.
but punishment under a
Correct.
misdemeanor? So if there's a violation, it would be a state jail felony
Correct.
conviction, correct?
Correct.
So, we don't usually do these up front, so I just want to make sure. Misdemeanor punishment, so that's, circle that. Okay. So, state tenors number 1.
No objection.
It's admitted. Is there any evidence that Ms. Webb is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. Mr. Coleman, what's the state's position with regard to waiving pre-sentence report? Since it's a state jail, is there any history?
Zero criminal history, Judge.
Okay, so I'm going to waive the pre-sentence report. I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 2 years. You're ordered to pay the $500 fine, follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because at the end of the probation period, if you're successful, the case is dismissed. You'll never have a felony conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty of the offense, which is a felony, and it would be a felony conviction. You could be sentenced anywhere in the range of punishment under 1244, which is up to 1 year in the Jefferson County Jail. Do you understand? I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. In just a minute, you'll just have a seat in the courtroom. There's a lady sitting right there at that desk. She's going to call you up when she's ready to go over your paperwork.
Judge, just to be clear, there's also a provision for no contact with Tashelle McKinney. And
Yes.
also stay away from Lamar University.
Yes, I did mention.
She doesn't live here anymore. Yeah.
And another important thing to know, Ms. Webb, obviously this is something that sounds like it's out of character for you. I sign early terminations for probation all the time. So if you get busy, do everything you're supposed to, pay your fees, do your community service, do everything right, you can actually get off of this probation early as well. So make sure you get out there, do everything you're supposed to. If you don't live here, then you'll talk to probation about where you live. They'll transfer it where you live. The important thing about that is it's kind of double duty for you. You're going to report in person wherever you're living, but they're just supervising you as a courtesy is what it's called. Your probation's still here and you're going to have to report here either by mail or online. So you need to make sure you do both. Okay? All right, just have a seat here in the courtroom. She'll call you up when she's ready to go over your paperwork. And then Mark Hebert, Mr. Parker. Good morning. Are you Mark Hebert?
Yes, ma'am.
My computer is going extra slow today.
What is the computer?
Mm-hmm. Me too, maybe, but the computer is winning on the slow. It's just
Doesn't seem to
spinning
be
now.
as busy today.
Huh?
Doesn't seem as crowded today.
No, it's kind of a smaller docket that we have. Okay, here we go. And will Mr. Hebert waive the formal reading of the indictment?
Will, Your Honor.
Mr. Hebert, in cause number 250455, you're charged with the third-degree felony offense of driving while intoxicated, third or more, from April 16th of 2024. The indictment alleges you were previously convicted of driving while intoxicated March 31st of 2010 And then after that, January 8th of 2013. And how do you plead to that charge? And are those prior convictions true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you with?
Speak up, yes. Yes, I'm sorry.
And I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you reached is for a 5-year term in prison, but that would be probated for 5 years. You'd be on probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Also, it looks like there would be a dismissal.
Misdemeanor.
A misdemeanor, what kind of case?
It's a harassment.
Okay.
I actually have the cause number now.
Judge, if I may hold off on that until sentencing, just so.
Sure.
Right.
Yes, sir. Yes, ma'am. Is that your understanding of the agreement?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number
No
1.
objection.
It's admitted. Is there any evidence that Mr. Hebert's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you at sentencing.
Thank you. Thank you.
Thank you, Judge.
Thank you, Mr. Parker.
I want you to know that I beat Charlie real awesome today.
You, I don't think he's on the docket.
I know. A point.
That did not matter.
I know.
Let's change it up. Let's go to Wisconsin and Judge Mogan, where she's about to have a hearing, it looks like, on custody of a dog.
Judge,
Good, how are you?
I'm doing all right. They said have kids. A kid gave me a hand by the mouth.
Oh,
And I was out for like a week and a half trying to get over that.
been there, done that.
Still.
Good morning.
Appearing in person without
There we go,
counsel.
sorry.
Ms. Hutari appearing without counsel. We're set today in this matter on Mr. Hess's petition for replevin. He's asking that a 7-year-old German Shepherd be returned to him. Basically, that's all I have in this case. This is set for a court trial. It was in front of Commissioner Krupa. However, Commissioner Krupa was not able to reach any determination, as this matter is a contested replevin. Mr. Hess and Ms. Hutari, please stand up, raise your right hands, and be sworn in.
Do you affirm that the testimony you're about to provide in this matter should be the truth, the whole truth, and nothing but the truth?
Yes.
Yes. You may be seated. Mr. Hess, this is your motion, your hearing, and so you have the burden of proof, and you are first to present your case. You may begin.
Your Honor, about April of 2023, Ms. Hutari and I separated or stopped dating, cohabitating. I moved out. At that time, she gave me Simpson, the German Shepherd. The understanding was that I had someplace stable for him to go to keep him, and that I would bring him back to visit. I followed through with those. I brought him back to visit after a number of visits. She said, "I don't want you to bring him anymore. I don't want anything to do with you." So I stopped doing that. Fast forward to April of 2025, this past April, I went to jail for a few weeks, and Rose called my mom, said we had some understanding that if something happened to me, that she would get Simpson back. And she came and took Simpson. When I got out of jail, was my first opportunity to have any contact whatsoever. I sent her a text message And here is a copy of that thread.
Can't present it yet. You have to tell me
I'm
what
sorry.
what it is and let me know if
This
it's gonna
is-
be relevant.
This is a chain of text messages between Rose and I when I first got out of jail. This is the contact that we had. I asked her how Sampson was, can I see him, can we get him, whatever. And she was adamantly said, no, not a chance in hell. She wasn't gonna let me see him, wasn't gonna let me anything. Sampson, I got hurt in January of 2023, broke my foot at work, didn't heal right. Fast forward, I'm still going through therapy. I have an implant. Sampson's been my emotional support through the whole thing up until April when she took him.
Oh, all right. You have text messages.
Yes.
Other than her saying, no, I'm not giving him back, what else are you trying to prove?
There's relevance in here, Your Honor. She
And I'm
said,
just gonna say, you have to stop talking when I'm talking. You can't talk over me. I have a court reporter who takes down everything. She can't take down two people speaking.
I'm sorry, Your Honor. In the text messages, the thread was our original agreement. She says why she removed herself from that agreement. And she also admits that Sampson was my support and Sampson was trying to save me and keep me. And she says that I failed him. And it also points out that Ms. Utari thinks that I should be locked up behind bars. I'm not sure where she gets her information or her evidence or anything like that, but I've not been convicted in any court in this county or state or
That's not
country.
relevant for today, but yes.
I agree. Thank you. That's what I was getting at. Okay, because we're gonna hear that. It also shows that she said that it's in here that Sampson was trying to save me. She recommended that I go see Jeannie Daniels, a medium in Frederick, and I did. I took Sampson with me, and Ms. Daniels said that Sampson and I have not just met, we've met before. Her first question to me was, do you believe in reincarnation? I said, I'm not opposed to it. I'm not closed to it. I don't have enough information to make that decision. And she said that, well, you and Sampson were in a life together before.
I don't know who Jeannie Daniels is.
I didn't either. She is a medium. She's very, very respected in her work area. Rose suggested we go see her.
All right, so what you have to prove to the court is that you are in proper ownership of Sampson. I haven't heard when the dog was received or purchased or gotten as a gift.
Sorry, April of 2023, sorry. After we broke up, there was some concern. I asked her what we're gonna do with the kid. She said he wants to be with you. He's followed me around since.
Again, I haven't heard when you first received or got the dog. I'm hearing April 2023. That's
Yep.
when you broke up. I'm not seeing how the dog poof came into your life.
That's what I was trying to explain, Your Honor. In April of 2023, about April, was when I moved out. We had a conversation, what we're gonna do with the dog. She said, he wants to be with you.
When did you get the dog?
April of 2023.
Oh, so he just magically came up in your life in April 2023. When was the dog first received? From Miss Hutari? Did she buy the dog from a
First received.
pet?
First
place?
received by her.
From anybody? How did the dog come into ownership of anybody?
She bought the dog from her cousin in Pine City, I believe it was. He's 2018.
And were you together at that time?
No, we were friends.
Okay. All right, and then so when did you and Miss Hutari get into a relationship?
2020. But we'd been friends before that. I've known Sampson since he was a puppy, since she got him. She'd actually gotten him for her ex-boyfriend.
Purchased him for an ex-boyfriend?
She purchased him and was going to give him to an ex-boyfriend, yes.
All right, and then you're indicating or telling the court that in April 2023, when you broke up, she gave you, Miss Hutari gave you Sampson and said that you would give him a stable life. Do you have
Yes.
any proof other than your conversations?
Yeah, right, the text messages. there's no denial of her giving them to me. She admits that she gave him to me, that he was my dog.
Okay, where in those text messages would it say that?
Page 3.
And what does it say?
Well, I went through, okay, it says it was never that I didn't want Sammy. It was 100% that I didn't want you in my life at all. You had him and you went there. Sammy has served his time. Now it is time for him to relax and have a normal life.
Where does it say that she gave him to you?
Well, that is her response. There's no denial that she gave him to me from my text. My text. Would you like me to read my text?
No.
Okay.
What I want to know is, okay, it could be a gift. It could be a contract. It could be something of that. I'm not hearing what it is.
It was a gift. There was no contract. Verbal contract. That was it.
Okay, so as a gift, she gave him to you in 2023. And
Yes.
what was the conversation?
Conversation was, she said, if you have a stable place to take him, then yes, but I want you to bring him back to visit.
Okay. All right, and so you would like the court to receive those text messages?
Yes.
Please provide her, Ms. Hutari, with a copy as well as the court. I can have it, thank you. What else would you like me to know?
I'd like you to know that I've been working since I got Simpson to make him a support animal, a service animal. He has become an emotional support animal. And Rose knew that before, or when she gave him to me, that
Okay,
was,
unless you have a doctor's note, I'm not hearing as an emotional support animal.
yeah, I understand that. It's in the workings. Without airing out all my medical stuff to the court.
So since 2023, when you were in placement of, or you had custody of Simpson until April 2025, who paid his vet bills?
I did.
Is he up to date on his shots?
I'm not sure where he's at right now. I don't have his tag. I don't have any of that. Rose has had him since April. But he had his shots, yes.
April wasn't that long ago prior to that, when he was in your custody.
His shot should have been up to date. Yes, I took him up here to the animal wellness.
What else do you have for the court to convince me that you are the owner of Simpson?
Rose's testimony itself from when we met with Commissioner Krupa, there was no
Can't hear
denial.
what happened in Commissioner Krupa's courtroom.
Okay, can we ask Ms. Hutari if she gave Simpson to me?
You're going to be able
She's
to
not-
ask questions of her later. Right now, you're giving your testimony. She's going to get to ask you questions, and then she's going to give testimony. You're going to get to ask her questions.
Okay. I don't have any paperwork. Simpson's tags are on my keychain, and I have no access to my keychain.
Why do you have no access to your keychain?
Because my vehicle is an impound in Sawyer County.
All right. Okay, Ms. Hutari, do you have, the court will receive Exhibit 1. Ms. Hutari, do you have any questions for Mr. Hess? Hearing his testimony, you have no questions.
I know I can say that I gave I let him take Sampson in April of 2023 with conditions that he was able to provide a stable home for Sampson and take care of him. I can say I have the copy of the records of when I purchased Sampson and February 27th of.
Well, there is no dispute that you purchased Sampson. There's maybe argument that you purchased him for an ex-boyfriend, but Mr. Hess agrees you purchased him. It was originally your dog. You got into a relationship, and when you broke up from that relationship, you gave him Sampson.
With conditions.
All right, so explain that.
I gave him Sampson with conditions. I knew that Mike wasn't in a spectacular headspace, and I thought that having Sampson to take care of would help keep him in a better place. Since then, Mike has been in and out of jail. A couple of times, Sampson has wound up in the pound. I believe when he was arrested in Sawyer County, Sampson wound up in the pound then. I have since taken Sampson to the vet, the same vet, got his shots and everything updated. They were not they were not current. I have the same text messages as part of the restraining order that I have against Mr. Hess. He has been, I have video of him driving by my house. I
don't need to hear that. That's not relevant.
Okay. He lives with or spends a great deal of time with his girlfriend. She lives in a trailer court where the dog's not allowed to be.
Not true.
You can't talk while she's talking.
The owner of the trailer court said that.
Can't tell me what people say.
Okay, I'm sorry. The dog is with me. He's safe. He's in one place. He's no longer being drug all over the world. He's calm. I have someone who can attest to his demeanor now versus what it was before. Sampson is safe with me.
So you admit that you gave him Sampson in April 2023 because you thought that he needed Sampson for whatever reason, but you said you gave him with conditions.
Mm-hmm.
What were the conditions?
The conditions were that he provide him with a stable, safe environment with him, not with his parents while he spends months in jail. It was for Mike to have him and take care of him, not someone else. And as I said, he's been in and out of jail several times. It's not fair to the dog to have him going back and forth. And like I said, at the point that I stopped taking Sampson, it was because I believed that Mike was doing things he shouldn't be doing. And I made the choice not to have Mike in my life, not the dog, Mike. I own a business. Things in his character are not something I want associated with myself or my business. I went the last time that I made the decision. Mike was in jail on a $25,000 bond. I thought at that point that they were going to keep him. I finally felt safe and comfortable enough. I reached out to Mike's mom. I explained to her that when I let Mike take Sampson, it was under the agreement that he was going to be able to take care of him, provide him with a safe place to be. And she said, okay, you can come get him. And I went there without any ill will from his parents, and picked Sampson up and brought him home. When they did release Mike, actually his first contact with me was when he called me at my business on my business phone and asked if he could see Sampson. And I said, asked how he was doing. I said he was doing well. He asked if he could see him, and I said no. And he asked what I meant by that. I said, you've chosen your road. You've made your choices. No, I don't, I am not going to let you see him. He said, aren't people allowed to change their road? And I replied and said, yeah, we've been down that road before also. And I hung up. Then he sent me the text message going on about a bunch of like whatever past stuff that has absolutely nothing to do with him having Simpson. He just repeatedly tells me that I'm wrong and I shouldn't have him. And like I said, there was a time that I had great faith that Mike wouldn't go back down the ugly road that he did. And that's why I trusted him to take Simpson. He chose to go back down that ugly road.
All right, so one of your conditions was that he provide a stable home for Simpson. By stable home, did you go over what you meant by stable home with Mr. Hess in April 2023?
No, I thought it was obvious at the time. I didn't go into detail.
Did you go over any conditions with Mr. Hess that were clear for him to understand that if he does X, that he will no longer be able to have Simpson?
Verbally, no.
Why do you think Mr. Hess is unstable?
He has several open court cases for methamphetamines, narcotics, having a firearm after being a felon. He could still very well wind up in prison. He has I have pictures of him driving by my house, yelling for the dog. I have pictures of him going to my place of business and dumping fish guts and rotten bait into my dumpster. He purposely, when he did that, was sneaky about it, drove around the back where he didn't know that I had a camera. I believe that was on July 13th. I don't believe that shows actions of somebody who is adult enough, grown up enough to handle the situation. I hope that, you know, Mike finds recovery and maybe some time down the road when I believe that he is in a better place, I would allow him to see Simpson, but at this time, I don't think he's in a very good place. And I personally do not want him in my life.
All right, anything else you would like me to know? Mr. Hess, do you have questions for Ms. Utari?
Yeah, what communication did you have with me when you decided you were going to call my mom and tell her whatever story you told her to get Simpson back? Why is it okay to approach that and not have me involved in that whatsoever? He was my dog, after all. You gave him to me.
You were not attainable. You were in jail.
People are absolutely allowed communication in jail. There is no communication.
You can't, you're not testifying right now. You're simply just asking her questions.
I understand. So you didn't get a hold of me because you thought I was unattainable in jail?
Correct.
Okay. I heard something about being mature enough to handle this the way it should have been or something. It's ironic. So do you think you handled this the correct way?
Absolutely.
So in my head, I'm drawing a picture of, okay, Mike's in jail, regardless of why. I think it's okay to just go get Samson, even though it's his dog. I'm going to decide what's best for Samson and what's best for Mike and everybody else right now, because that's my duty, is the kind of impression I get. Am I wrong?
Yes, you are wrong.
Okay, could you clarify that for me?
Your actions showed that you were not there to take care of him. You yourself said that you were in jail for a couple of weeks. You left his care to someone else.
Okay, is that not my right? Would you leave his care to somebody else if you had to take care of something personally?
Situation is a little different. You were.
I don't think
in
so.
jail.
You're not arguing back and forth. You're allowing her to answer the question, and then you can ask her another question.
Okay.
You were certainly not in jail of your own will.
Okay, I don't think that's relevant, but
Are you objecting?
I am objecting, yes.
You don't think it's relevant?
That I was in jail and not of my own will. I don't think anybody volunteers to go to jail. It's not a,
No.
it's not an option program.
But yes, but it is relevant. So yes, you have to
Okay.
answer. Or it is, her answer is allowed.
Okay. Have you seen the pre-sentence investigation for any of my cases? Have you talked to any attorneys or any legal professionals? And do you know my sobriety date?
That's a compound question. What do you ask?
Here it is, you're right. First, I would like to know if you spoke with anybody in the court system to say that I'm going to prison, or there's a high likelihood that I'm going to prison.
Actually, when we were in front of Commissioner Kupra, he was looking through your files and said, this one alone is 12 years.
Exposure.
And he asked you at that point also, when you went to prison, where do you believe that the dog should be? And you said, with me.
Okay.
As far as your sobriety goes, I don't have a lot of faith in your sobriety, in that I see you in and out of the bar regularly. Even if you're not using meth, you're still using other things. And just a few weeks ago, on, I believe I have the date written down, you pulled up in front of the Clam Falls bar. Your girlfriend who's sitting next to you got out of the bar, walked into the bar, got a drink, turned around, walked directly back out and got into your vehicle with the drink.
You witnessed this?
I witnessed that.
What kind of drink was it?
Well, and I'm going to say that part's irrelevant. What the girlfriend does is not relevant to what Mr. Hess does.
Do you have access to any of my urinalysis? Excuse me, urinalysis samples?
I do not.
Do you know how many I've taken in the last month?
I do not.
3.
You're testifying, so that's.
Oh,
checking. You
sorry.
can't
I
testify.
apologize, Your Honor. What harm has befallen Samson because he was in my care?
He was incredibly erratic. He was always on the defense because you put him in different situations all of the time. The only reason that you, and you personally told me about this, is that you were making an emotional support animal so you could take him into bars. And they couldn't tell you he couldn't be in there.
I object. That is not how I said that.
I'm overruling it. It can stay.
He would spend hours and hours sitting in your truck outside of the bar. At one point, when I did have Sampson, I had taken Sampson for you. You had Stephanie Fisk come and pick him up from me at my store. Several hours later, I was out on a delivery and saw Stephanie's vehicle sitting in front of the bar with Sampson still sitting in it. I had to message you, and I at that point said if she was just going to leave him sitting in front of the bar in her vehicle, there was absolutely no reason he couldn't have just stayed with me. You then called her and made her go take him home.
So I did what was right at the time.
Are you testifying or asking?
I'm asking
her
a question. Do you think I did what was right at the time then?
Only after I said that I would go get him if you did not.
After you called me and made me aware of the situation, I did what was right for him, then you're saying? That was a question, sorry.
Probably.
So I hear you use a lot of words, erratic and stuff like that. Where did those words come from, or whose diagnosis is this?
Can I ask somebody to come up?
You may not. Okay. You get to have a witness testify later, but right now you are on the stand.
It's the behavior that I witnessed, that I would see. He would walk through the crowd. He was always nervous. He was always high strung. Recently, CarQuest is a place that Mike would often take Sampson to, CarQuest in Frederick. I recently walked in the door with Sampson, and the gal behind that works there said, "Oh my goodness, where did you get such a calm German Shepherd?" And she was petting Sampson, and the owner said at that point, he said, "Yeah, he's like that now. He wasn't."
Well, you can't
and I know that's
testify.
hearsay.
Unless you have her here to testify, that doesn't come into the record.
Okay. I guess that's all that I have.
Where do you get the information about Stephanie's landlord not allowing the animal on the property?
From him, from the landlord, from Craig Swanson.
You had mentioned before something about his insurance not covering an animal.
Well, I'm going to say none of that is relevant. Well, it could be relevant, but it's hearsay. I don't have the landlord here to testify,
Okay.
so I don't know if it's true, it's not true. I don't know what it is, and it doesn't come in.
Point made, Your Honor. Thank you. Do you remember when you suggested I take Sampson to see Jeannie Daniels?
Yep.
Do you remember what happened in that interview or that appointment?
Yep. And when I got Sampson back, I took Sampson to see Jeannie. And she was amazed at what a different dog he was in my
Objection,
And
Your Honor.
I'm going to say it shouldn't have even come in with the whole Jeannie Daniels and you've met Sampson in another life kind of thing. Unless they're here to testify, it can't be evidence. Can't
Okay.
come in.
Do you think Sampson is a support animal for me?
I believe he was at one time. I believe he no longer is.
I don't have him, of course not.
Is that a question?
No, Your Honor, I'm sorry. Do you think there is no hope for me? Do you think I am just, my life is not at this point?
I don't see how that's relevant.
Would you like me to
It's
explain?
not relevant.
Okay. In your text message, you said that Sampson tried to save me, but I failed him.
I did.
Okay. For me, that gives the impression that you've given up on me, that there's no hope for me.
It's irrelevant. my opinion of you, what shouldn't matter to you.
It doesn't matter to me. It matters to the court, I believe. No?
Doesn't. And quite honestly, if you have hope, if there's hope for you is so speculative, I don't even know what that means.
I guess I have nothing else, Your Honor.
You have no other questions? Okay. Before we move on, I have perhaps a couple questions for both of you. Mr. Hess, in the texts that you have had as Exhibit 1, I believe you are in the blue, and it
Yes.
says there were 2 conditions when you gave me Sammy. One was a stable place to live. He had that when you took him from my mom's. Was Sammy living at your mom's?
Sammy was staying, I lived with my parents. I left Samson with my mom and dad when I went to jail.
You live with your parents?
Yes.
So you still live with your parents?
Part-time, yes. Well, yes.
Why do you mean part-time? Because you stay with your girlfriend?
I stay with my girlfriend at times, yes.
So when you moved out and broke up with Ms. Hutari, you both lived together prior to when you were in a relationship, is that
Yes.
correct? And then when you broke up in April 2023, you moved in with your parents?
Yes.
And so you moved in with your parents, and that's when she gave you Sammy?
Yes.
And so you had your mom and whoever Floyd is watch Sammy when you were in jail?
Yes.
How long were you in jail?
5 weeks.
Okay. And with the conditions, I think I only see one was that he have a stable place to, oh, and the other that you bring him to visit.
Yes.
And what does it mean by you bring him to visit? You go and you spend a couple hours together, or you drop him off for a weekend?
The understanding I had at the time was that I'd drop him off and let her spend a day or a night or a weekend with him.
And then when did she say, I don't want to have those visits anymore?
I think after the 3rd visit, so approximately 5 weeks or so.
You would say approximately June of 2023?
Beginning of June, end of May, yes.
You had Sammy from April 2023. She last saw Sammy June of 2023, correct?
Yes.
Now, where she condition where she states the condition is a stable place to live, what did you take that to mean?
I thought that meant that someplace where we could lay our head at night. Someplace safe, somewhere where we get shelter, food. Someplace to call home.
All right. Ms. Hutari, in April 2023, when you gave Mr. Hess Sammy with conditions, did you know he was living with his mother and Floyd?
He was not. He was living in an ice castle in Siren, Wisconsin, in his buddy's front yard.
Okay, so when you gave him Sammy, he was living in an ice castle.
Correct.
And so you thought that that was a stable environment? Yes or no?
Yes.
So you thought then why did you say it with such disgust?
Because he lied about he omitted the fact that that's where he lived.
How long do you believe he lived in that ice castle?
I am unsure. I very much limited my contact with him. I avoided going places where he was, so I truly am not sure.
But you believe him living in the ice castle in the driveway or yard of his friend was stable?
Based on the people that lived in the house, yes,
Do you think his mother and Floyd are stable?
I do.
Mr. Hess, when did you move? You lived in an ice castle, correct?
I stayed in my buddy's ice castle as soon as I got out of jail, yes.
When you got out of jail?
No, it was when I left Rose's,
How long did you live in that ice castle?
about a month and a half.
And then what, so then that was approximately May or June?
Yeah, it'd have been June, end of June.
And then you moved in with your parents?
Yes.
Well, with your mother and Floyd.
He's my stepdad, yes. He's been
Okay.
everything of a dad to me. I can just call him dad would be fine.
And so did you inform Ms. Hutari that you were moving in with your mom?
No,
You know how she found out you were living with her mom? your
no
mom?
idea. By that time, she had said she didn't want to visit anymore.
When were you arrested and in jail for 5 weeks?
Beginning of April, 2025.
Or just recently?
Yes.
Did you pay bail to get out?
Yes.
How much was bail?
$2,500.
2,500. And so you're on certain conditions right now?
Yes.
No drink,
No drink,
no illegal substances?
no illegal substances.
You have a curfew?
No. I am under the supervision of Justice Point out of Sawyer County, and I'm in programs for change in, Sawyer County's Justice Point. I'm enrolled in
I'm well aware of it.
programs for change in Polk County.
Okay. All right. Do you have any witnesses?
No, no, Your Honor.
Do you have any witnesses?
I have Sharice Miller, who occasionally helps me at my shop. And she can attest to the difference in Sampson now versus what he was when Mike had him.
All right, Ms. Miller, please come forward. Raise your right hand. You'll be sworn in and then come have a seat at the witness stand.
Do you affirm that the testimony you're about to provide in this matter shall be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, so you'll be over there.
When she's seated, you may begin asking her questions. Catch her name. Charlene Miller?
Sharice.
Sharice. Sharice Miller. All right, can you spell Sharice?
CHERRISE.
All right, you may begin asking her questions.
Sharice, can you tell me about how Sampson would act when Mike would bring him into the store?
When Mike and Sampson would come in, Sampson never left Mike's side very much. He was very, very skittish. His ears were down, his tail was down. When I try and approach him, he didn't like being approached unless Mike was with him, and then I could pet him a little bit. But then he would like go away. When someone came into the shop, I remember the huge bark he had, and we just had to kind of calm him down, or I should say Mike did, kind of calm him down and bring him back to the back of the store. Now, since then, it was just within the last couple of weeks when Rose brought Sampson into the shop, and his ears were up, his tail is wagging. He came over and he darn near knocked me over by sitting on my feet and wanted to be pet, followed me around. He's a day and night dog. It was quite an improvement that I saw since he's been with Rose.
But you haven't seen Sampson, you saw him that one time in 2023.
Just when Mike would bring him into the shop.
How many times did you see him in 2023?
Oh my goodness, probably, I know twice for sure.
And that was shortly after the two broke up. They terminated their relationship.
Actually, no, they were not broke up at that time. Mike was just with Sampson and came in just Mike and Sampson. Rose was not at the shop at that time.
All right. So when you saw Sampson back in 2023 at the shop, you believe Mr. Hess and Miss Hutari were still in a relationship?
Correct.
Okay. All right. Other questions, Miss Hutari?
No.
You have questions for Ms. Miller?
No, I don't.
All right, you may step down. Thank you.
Thank you.
Any other witnesses? All right. One last time for either of you to provide me with any testimony, any evidence.
No, Your Honor.
Okay, argument, Mr. Hess.
None.
Ms. Hutari, any argument?
No.
All right, well, when you look at this case, this is McLevin, this is dealing with an animal. An animal is a piece of property. I know to people, it feels like a kid, as you explained, Mr. Hess. I too have dogs, I have cats. They become part of your family. Animals can feel like they are members of your family. So I understand that. And I understand how both of you feel very strongly towards Sampson. You both want him to be healthy. You both want him to be happy. And you want him to thrive. Originally, in the beginning, Miss Hutari was the 100% owner of Sampson. She purchased him back in 2020. She may have purchased him for an ex-boyfriend and gifted him to the ex-boyfriend. Ex-boyfriend didn't take him or have him, so he remained property of Miss Hutari. You both got into a relationship, and then in about, well, she purchased him in 2018. It was 2020 when you got into the relationship after being friends for a while, and then you terminated your relationship. You went your separate ways in April of 2023, and you broke up. Both of you admit that this was a gift, that Miss Hutari gifted Sampson to Mr. Hess. You both indicate that there were conditions upon this gift. So this is a gift with conditions, and it is something that can be done. It's a conditional gift. It means a transfer of property where the recipient must fulfill specific conditions, not only to receive, but to keep this gift, this property. And the two conditions were, one, that Mr. Hess give a stable place for Sampson to live, and two, that Sampson be able to visit with Miss Hutari. Sometime down the road, Miss Hutari, after approximately 3 visits or so, wanted to sever all ties with Mr. Hess, and you indicated, Miss Hutari, you were done. You didn't want to have those visits anymore. You didn't want to see Mr. Hess because seeing Sampson means Mr. Hess comes with him. And so you cut off, or you canceled and you terminated that condition. So what remains is the condition of stability or stable. I have in writing in a text message that one of the conditions was a stable place to live. And that was put into a text from Mr. Hess to you, Miss Hutari. Ms. Hutari, when you testified, you indicated that you did have the condition of that he have a stable environment. When I asked you what that meant, you said, well, we didn't talk about it. I didn't explain what that meant to have a stable environment with Mr. Hess. That means that that term is not defined. It needs to be defined. You need to say you need to have a stable environment where he's going to have a place to live. He's going to have food. He's going to have a bed to sleep in. He's not going to be subjected to this, that, or the other. I understand your concerns that he's left in a car while Mr. Hess is in a bar. You didn't define stable. You didn't define stable environment. And I heard the testimony of Miss Miller. She's a great friend and a great employee and she wants to be there to support you. She testified as to a condition of Sammy when you two were together. So he was erratic when you two were together. So I don't have any starting point of when he was simply with Mr. Hess versus when he was with both of you together. So by hearing that testimony, it hears that you may have been part of the problem or whatever made Sammy erratic. Maybe it was the tension that Sammy felt between you and Mr. Hess. Maybe you were arguing all the time. Animals are very intuitive. They feel our emotions. They feel when we're sad. They feel when we're happy, they feel when we're nervous. They feel all of those things and they are there. And so all I have to go on right now is that condition of a stable place to live. Now, I probably wouldn't have defined living in an ice shack for a period of time as a stable place to live. It's not a home. However, you didn't find an issue with living in the ice shack. You liked where his friends were, who his friends were. You liked that it was, I guess, he had a place to live. But within a month or two, he moved in with his parents, them as being stable people, his mom and Floyd. Stable people. Sounds like you have good affection for them, or you don't have anything negative to say about them. So he had a stable place to live with Sammy. So that to me, he meets that condition. Whether or not he's in jail for 5 weeks or whether or not he's in jail perhaps maybe a little longer than that will be unstable if he's not able to take care of Sammy. But that was not a condition. Your condition was not, you can have Sammy, but only you have to take care of him. He can't be anywhere else. You can't leave him in your car when you go to a bar. You can't do this. You can't do that. Your condition was a stable place to live. Mom and Floyd are stable. He was temporarily allowing Mom and Floyd to take care of Sammy, not removing him from that environment. And you no longer wanted visitation with Sammy. So had you wanted that visitation, I can see that it would be part of the gift, the conditional gift, that Mr. Hess call you up and say, Ms. Hutari, I'm in jail. I can't take care of Sammy right now. Can you take care of him until I get out of jail? But you didn't want to have those visitations, and he was not under that requirement to notify you about that. And as I see it right now, yes, he may have open serious cases in Sawyer County, Polk County, whatever the counties, he may be under conditions. However, at this time, Sammy has a stable place to live. He's living with his mom and Floyd. You can't take Sammy back and forth to your girlfriend. His place to live is with your mom and Floyd. That's the stable place. If you get your own environment, your own home, and Sammy can move to that home, that would be stable. You can't bring him back and forth. He has a place to live. And it's with Mom and Floyd until you have your own place to live. But I can't find that he violated the condition of a stable place to live because Sammy has that. However, I will say it will violate that condition if he goes to prison or if he goes to jail for a lengthy period of time. 5 weeks is not a lengthy period of time. He could have went on vacation for 5 weeks. Regardless of where he was, he left Sammy in a good home being taken care of by his mom and Floyd. So he did not violate that condition. So I'm finding that Sammy belongs with Mr. Hess, and he must be turned over to Mr. Hess within 1 week. If he's not turned over within 1 week, you will violate the court's order and you could be held in contempt. The only condition that remains is he provide a stable home. If you can provide concrete information that he's not providing a stable home for Sammy, then he violates that condition, and then Sammy could be returned back to you. I don't find he violated that condition. I find you actually violated it by going to his parents and removing Sammy or telling them that I am here to take Sammy back. He didn't violate that condition. So Sammy is rightfully a gift to Mr. Hess with now the only remaining condition to have a stable place to live. It's unfortunate, I understand. You went 2 years without seeing Sammy, 2 years without seeing Sammy, being involved in Sammy's life. And that is hard on a dog as well. But I'm going to tell you, the dog remembers you. The dog remembers Mr. Hess, the dog will remember your ex-boyfriend if he had a relationship with him. Dogs are great that way. They remember happiness, they remember horror. So within 1 week of today, which would be July 28th, Sammy must be returned to Mr. Hess. Mr. Hess, I am telling you right now, you must have a stable, as you say, a stable place for Sammy to live. He can't be brought back and forth. He really shouldn't be kept in your vehicle while you're at a bar. He shouldn't be, not looked at or taken care of. And I don't know if you did or did not have his shots up to date, but that's a part of being a good pet owner. You have to keep him up to date. Not only is it for Sammy, but it's the law. Okay, he needs to ensure that he has his rabies and all of those other things. So again, that is the order of the court, and it's unfortunate because I think Sammy sounds like a very, very good dog, and it's unfortunate that your relationship ended the way it did. I'm not going to go into what you are allegedly committed or allegedly
Accused of?
charged with in those actions. Mr. Hess, it sounds like that if any of those allegations are true, you better get your life back in check. Because if you continue down that road, that is going to be a violation, and Sammy deserves better than that.
Does.
All right, so that is the order of the court.
With the restraining order in place, we might want to talk about how to get the dog.
Is it,
to
has he
him.
been served?
I don't think he's been served, but in Polk, they're probably going to serve him within this week.
Polk County actually asked Burnett County to serve it. They haven't been able to catch up with him at his parents' house because he's always at his girlfriend's house.
Our clerk checked with our Polk County or our Burnett County Sheriff's Department, and we don't have it, do we?
I didn't get the.
They had it.
Because I realized it wasn't our restraining order.
Oh. Well, then it can be 1 week exchange here at the government center within 1 week. When would you like to exchange the dog?
I don't know. Can't believe this is actually happening.
That's why you have to be specific and clear in your conditions. All right, then I'm just gonna say Wednesday, 1 o'clock.
I have group on Wednesdays, Your Honor. Would you like me to cancel, or
No, I do not want you to cancel group.
Tuesdays and Fridays are open for me?
Then Friday at 1.
Cancel group to be here today.
No, I didn't.
Well, I don't want him canceling group because if he goes to group, that's showing that he's trying to improve his life. He's trying to remain sober. I don't know what the full allegations are against Mr. Hess. I have heard that it involves illegal substances. All right, Friday at 1, Government Center.
I won't be here Friday.
Well, then Tuesday at 1.
So tomorrow.
Tomorrow at 1. Right in front of the Government Center. Again, now we're very clear at what the condition is. A stable place for Sammy to live, food, shelter, bed.
He goes to prison.
Well, he goes to prison, obviously, you get the dog. That's not a stable environment. He can't give the dog then to his
Moving the
mom
dog
and
back
dad.
and forth isn't stable either, but.
Going where back and forth?
Then why'd you remove me from my parents?
Between the parents and me.
No, it won't happen. If he violates that condition, he goes to prison, he can't provide a stable home for him. That means he goes back to you. He can't then say, Mom and Dad take care of him for however many years I'm going to be in prison. That is not a safe environment. Granted, he would be safe with Mom and Floyd, but if he goes away for a significant amount of time to jail or to prison, and I'm going to define going to jail about a year or prison, or 6 months. That's not a stable environment.
Correct.
Okay? And you can't then pass off Sammy to be taken care of by your mom and Floyd. That's why it's very important if you gift somebody with a condition, it needs to be very clear what your statement was, because you did testify that you gave him Sammy because you believed he was not emotionally handling things well and that he needed Sammy. And then you testified that he lived in an ice shack. Those don't sound stable to me, but those were the conditions upon which you gave Sammy. So it has to go from there. All right, tomorrow at 1. We are adjourned.
Okay, friends, so a couple of things. First off, they were discussing at first how he lived in an ice castle, and then they revised it to ice shack. So I don't know what's really what, but I did look up ice castles in Wisconsin, and they are a thing. This is from eagleriver.org, where in Eagle River they do ice castles. And here's some pictures of them. They harvest these ice blocks, and then they build them up into a castle. And it's kind of interesting. And there you can see like the finished product, and it's kind of a touristy type of thing. See, they harvest it right from the probably the river right there, or the lake or something. But you can see how they're pulling the blocks out. This is something they do in the Norwegian countries too, I know. But it is really a thing. So, I mean, he said he lived in an ice castle. Maybe he meant an ice shack, like a fishing shack or an igloo or who knows what. He could have also meant that he was working at one of these places as a caretaker and perhaps living in some kind of shed on the side or something like that. But yeah, it's a thing. So I thought I'd share that. Also, because I was curious, you know, we're talking about the animals and we're talking about, you know, their rights and where they should be and how often they're like almost a custody dispute, even though they're property. So it reminded me of something. I don't know if you guys have ever heard of this, but down in Colombia, because of Pablo Escobar, there's a whole bunch of hippos, and they're actually called the cocaine hippos. Escobar had so much money that he started not knowing where to spend it. He started assembling a quasi-zoo. And they've since moved all of the animals and rehomed them except for these hippos, which are nearly impossible to move because they're so large and so dense and so powerful. But they're in the rivers there. They keep multiplying and multiplying, and there is a very natural disaster going on there now because of these hippos. They're destroying the ecosystem to the point where other species are dying off because their poo destroys the water there. The poo creates this algae that eats all the oxygen out of the water, and everything in the water dies off. So there's this concern about these animals getting into the jungle and into the Amazon, and if that happens, it's going to be disastrous. And bottom line is, it's a thing that nobody knows how to deal with. Well, some people in the United States got all concerned, so they went and started petitioning the U.S. courts on this matter. And back in 2021, a U.S. federal court actually declared that the hippos were quote-unquote interested persons. So in a backdoor sort of way, they've granted, at least in theory, personhood to animals. Nobody's really run with that I can find and tried to bend it around into their own needs yet, but it's only a matter of time. Obviously, that ruling has no effect over the country of Colombia. They're going to do what they're going to do. But I just thought you would find that interesting because a federal court actually granted, in a backdoor way, personhood to animals. So it's really weird. So by request, here's the bears. I'm going to step out of the studio for about 2 minutes. I will be back. In the meantime, stare at the bears, and then we'll move on with court. Bailey, you're in charge. I'll be right back. Okay, friends, I'm back. I went and grabbed myself a lemon Greek yogurt and a few fresh blueberries to put in it because I was hangry after all of this. Let's let's do this because I promised 9 to 11% more Judge Boyd to keep people happy. Let's go to Judge Boyd.
Hey, Laura, can you move them to the other end? We're about to take up a hearing. Court is calling 2025 CR 007563 State versus Ronald Lamar Allen. Can I have parties announced?
Megan Galloway for the state.
Charles Butcher for the accused.
And are you Ronald Lamar Allen?
I am.
Right, so before we take up any settings of discovery issues, counsel, you filed a motion requesting a reduction of bond.
That's correct, Judge.
All right, and what is the bond currently set at?
The bond is currently set at $100,000.
And state, are you in agreement to reduction?
No, Your Honor.
All right. And state, are you prepared to proceed on the motion?
Yes, Your Honor.
All right, defense, it is your motion. Do you have any witnesses?
Yes, Judge. I have Miss Evelyn Allen is here. She's the mother of the accused.
All right, Miss Allen, if you'll come forward, please, and sir, if you'll stand near that computer. Yes. Can you raise your right hand for me, please? Do you solemnly swear upon the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. I need to make sure you keep your voice up because one, I need to hear you. And also the court reporter needs to hear you. Cindy, do you need her to wear the little microphone or no?
No, she's in front of the mic.
All right, if you'll state your name for the record, please.
Evelyn Allen.
All right, that's the right tone.
Oh,
for me to
good.
hear. Thank you. All right, defense, you may proceed.
Miss Allen, are you the mother of Ronald Lamar Allen?
Yes, I am.
And how long has Ronald lived in Bear County?
Over 8 years for sure.
And for the court, would you describe your relationship with your son?
We're very close. He lives with me, so he does help out around the house quite a bit. Like yard work, grocery shopping. We have a close relationship as far as sharing.
Now, Miss Allen, are you aware of any past instances where Ronald has failed to appear for the court?
No, not at all.
And under the circumstances of his custody battle, he's had to be in court a lot of times. Is that right?
Oh, yes.
And how long has his custody case been going on with the ex-wife or his ex-girlfriend?
Well, the trial is 8, so I would say close to 8 years old.
Now, are you aware of any past instances where Ronald has attempted to flee the jurisdiction or avoid any court proceedings?
No.
And if Ronald were released on a reduced bond, would he have a place to stay?
Yes.
And would you be willing to supervise or help monitor him if it was required by Judge Boyd?
Yes.
And can you describe any of Ronald's involvement in his family or community prior to this arrest?
Ronnie is very light. In fact, one of the neighbors is here with us today that he's helped out. She's had health issues and he would bring her hot meals, take care of her yard. We in an elderly neighborhood, he's helped the elderly clean their gutter if they need to move heavy flower pots, whatever. He was well liked by all the neighbors in the neighborhood.
Now, Miss Allen, have you ever made any efforts to post Ronald's bond?
I've made several attempts. I've called about 5 bondsmen, and each one had different regular stipulations. Once was like I needed 4 signatures, co-signers, they called them, that had to have employment and live in Bear County, that would be responsible if in the event he would skip out for the $100,000. Plus a collateral of putting my home for collateral. And then another one required, I think, co-signers other than me, two co-signers, but other than myself or my husband at the time, be at peace.
Now,
And and collateral, whether it be like any my home or with 100,000, and I think the bond, they started at 10,000, but said it could be up to the discretion of the manager of the bonds company. It could be more, but not less.
now, Ms. Allen, do you believe a lower bond would allow your family to safely and responsibly secure the release of Mr. Allen, of your son?
It would be affordable, yes.
And what financial resources have you exhausted trying to help Ronald?
I'm embarrassed to say, but I've limited out all my credit cards and all my credit. Thank you. And now that my husband's gone, that income is ceased, so it's it's very stressful and trying to find funds to.
Can you tell the court about your late husband, Ronald Wayne Allen?
Glad to. We were married in April for 52 years. We went to high school together. We had our class reunion, 55-year class reunion in September, which I'm glad we got to share that. And our anniversary, we're from Louisiana, so we got to share crawfish. And I'd like to say that for his final days, he enjoyed that, but it was a shock that he passed.
When did your husband pass away, Miss Allen?
June 13th.
And this was while your son was in the jail?
Yes.
And how did Ronald respond to the loss of his father while he was in jail?
Very stressful, very anxious. He just wanted to give me a hug and support, be with the family. At first, I don't think he realized that he had passed because I couldn't tell him. And I don't think reality set in now. He's very, it's stressful. He says that he thinks of him a lot, trying to sleep, and that just needs to give me a big hug.
Miss Allen, has Ronald been able to attend any funeral services or grieve properly regarding your husband?
Your Honor, because I have two boys and myself. We're waiting for Ronnie to be able to attend the services before we can schedule them. We're from Louisiana, so our main service would be in Louisiana, Lafayette, Louisiana.
Miss Allen, from what you've observed, does Ronald struggle with any mental health concerns?
Very anxious, very stressful. The stress being in prison, jail, how they call it.
And has he ever had any mental health conditions? Has he ever suffered from schizophrenia, bipolar disorder, or anything like that?
No.
And do you believe that Ronald would benefit from counseling or evaluation if released?
Oh, absolutely. He and I both to be able to grieve, learn how to grieve together and get beyond this, because we need closure and we need to share that bond. It's very hard for me all alone at the house.
Now, Miss Allen, regarding these underlying charges, have you ever seen your son engage in anything violent or have any violent offenses, or has he ever lashed out at you in any way?
No.
And regarding these underlying charges, maybe you can tell the court a little bit about what these charges have meant to you substantially.
Trying to understand the charges. At first I said, this doesn't sound like my son. But again, he can get excited, he can get anxious. He was struggling with the custody. And the process that was going on. And he can get excited and we're from Louisiana, so he may raise his voice, but as far as he wouldn't even hurt himself. I mean, he's very, very controlled person. He's very low key. I've never seen him ever say anything to harm anyone. And much, and I'm gonna bring in the custody was for his child that he loves very much. He's a very good father. They've always enjoyed very good times together. And so this was very trying and distressful for him. And trying to communicate with him about the loss of his dad and my grief, it's hard on the privacy of a phone for minutes at a time.
Miss Allen, I want to thank you for your testimony and again, I'm sorry for your loss regarding all of this and the stress that you've been under the last 90 days while he's been in jail. I'd like to pass the witness now, Judge.
Any questions?
Miss Allen, just briefly, I have a couple of questions for
I'm
you.
sorry.
I said, just briefly, I have a couple of questions for you, okay?
Okay.
You stated that your son moved to Bear County about 8 years ago.
Yes, I mean, he's been in Bear County as long as his child's been born.
Okay, do you know where he was living before that?
I can't, when they were married, they lived in, Wimberley?
Okay, Wimberley, Texas?
Yes.
And then, before that, did he live in Louisiana with you and your husband?
I've been in Texas for 52 years.
Okay, so at any point, did your son live in Louisiana or no?
He may have stayed there to help a family member. His grandmother had eye surgery at one point, and his uncle lived, well, that's Texas, so, just with his grandmother years and years, I mean, maybe 30 years ago, but when she had, but he never had a residence.
Okay.
He was
Just
helping
staying there.
caregiver.
Okay.
Yeah.
All right, thank you. And then are you currently working right now or are you retired?
I'm retired.
Okay. How long have you been retired?
21 years.
Okay. Do you receive like retirement from the government?
No.
Okay. Do you have like a 401k or any retirement from your job?
I have a retirement, but I don't survive on it. I
Okay.
survive on Social Security.
So about how much income do you get monthly?
I don't remember, but I think it's like, 1,500 or 1,600 a month.
And before your son's arrest, was he employed? Okay, what was he doing for work?
He was like, what I understand, a courier, like delivery.
Okay. Was he employed with like a company or self-employed? Do you know?
I think he mentioned, I didn't get too much into his business, but like a self-contract or contract.
Okay. And do you know what his like hourly rate was or monthly rate?
No, I didn't get into that.
Okay, do you know if he has any savings accounts?
I can't answer. I don't know.
Okay. You guys haven't discussed that in your efforts to make his bond? If he has money saved up to assist you?
When we talk on the phone in the prison, we try to keep everything generic for the privacy. Okay. And I get into financials to keep it private. So if
Okay, but you would agree with me if he had some type of money or savings, that would help you try to make his bond, right? That would assist you in your efforts. And then as far as your home, you said you've lived here for 52 years, so do you own your home currently or are you renting? You own it? Okay, and do you have a vehicle that you own?
Yes.
Okay, and what about your son? Did he have a vehicle that he owns? No. And what about a home? Did he have a home that he owned prior to this?
No.
Are you aware of any of your son's prior arrests?
When he had his divorce.
Okay, would that be around 2015? Have you heard that he was arrested for assault, family, house, impeding breath or circulation?
Is that important? I'm sorry.
Were you aware that in 2015 he was arrested for a family violence assault, including strangulation?
I was aware that he had a legal issue with his divorce, yes.
Okay. And then before that, in the year 2000, were you aware that he was arrested for possession of marijuana between 5 pounds and 8 pounds?
I believe that I had not.
You did? Okay. And then were you aware that in the year 2016 or 2015 that he was arrested for unlawful restraint? In 2015. Okay. And were you aware that in 2016 he was arrested for assault, bodily injury against a family member?
In what year?
2016.
No.
We pass the witness, Your Honor.
Any further questions?
Yes, I'll take short redirect. So, Miss Allen, you are aware that your son has had some violent instances, allegations. Where were these allegations regarding the family violence assault coming from? Like, who do you think is actually made these allegations against your son, Ronald?
The one that I said I was aware of would be the ex-wife.
And have any of these allegations and any of these charges in the past, have they resulted in Ronald going to jail or having a conviction?
Not that I'm aware of, no.
So he's never been in jail for this long for any of these alleged assaults from the past?
No.
And most of these are from over 10 years ago, or at least 10 years ago?
Yes.
And on the marijuana charge, that was in 2000, in the year 2000. He was a young man at that time, right?
Many years ago, yes.
And you were aware of that?
Yes.
In light of all of these items and these matters, has Ronald ever been violent towards you?
No.
Do you have an ability to supervise Ronald if he's released on bond and put under your supervision? All I have, Your Honor, regarding this witness.
All right, any further questions?
No, Judge.
Any objections to the court asking a question?
No, Judge.
All right. So in your home, are there any weapons? No guns?
No, ma'am.
And if your son were to make bond, he would be staying with you?
Yes, ma'am.
And is that in Bear County?
Yes, ma'am.
All right. Any other questions from either side?
No, Judge.
Any other
No, Judge.
questions with this witness? I'm sorry for your loss. It is so rare to see people who are high school sweethearts get married and that it lasts for that length of time. All right, thank you so much for coming in.
Thank you very much.
You're welcome. All right, call your next witness.
That's the only witness I have for today, Your Honor.
All right, state any witnesses.
No witnesses, but the state would offer states exhibits A and B for the purposes of this hearing, which is a copy of the prosecution guide and the criminal history of the defendant.
Any objections to the court reviewing?
No objections to that.
Just give me a moment to review. Counsel. All right, the court will hear argument.
Judge, in addition to all of this, I do have a copy of Ronald's father, Ronald Wayne Allen's death certificate, so that we know that this is an honest
Oh, no,
regarding this man. He was an Army veteran and.
all right, and I reviewed the document, and counsel, you're an officer of the court.
All right, thank you,
Thank you.
Judge. Regarding this matter, Your Honor, we're here today on this motion to reduce bond filed on behalf of Ronald Allen. Mr. Allen is currently sitting in the custody under conditions that neither reflect his flight risk nor serve the purpose of public safety. We think that this incarceration, in fact, functions as an instrument of oppression prohibited under the Texas laws and the United States Constitution. Under the Article 17.15 of the Code of Criminal Procedure, the court must consider the following factors. The bond must be sufficiently high to ensure appearance. It may not be used as an instrument of oppression. The nature and circumstances of the offense must be considered. The accused's ability to make bail must be regarded, and the future safety of the community and any alleged victim must be weighed. Further, Article 1.07 guarantees that bail is a right, and Article 17.09 permits this court to modify bail at any time prior to his conviction. The Eighth Amendment of the U.S. Constitution prohibits excessive bail, and the 14th Amendment's due process clause requires this court to avoid pretrial detention solely on the basis of poverty. The application to this case is that there's been no physical confrontation and no victim impact regarding this case. The underlying facts of the case would show that Mr. Allen was in a private conference with his custody lawyer at the time of the alleged offense. We want the court to understand that this was an emotionally charged conversation because of a long custody and visitation battle with his ex-wife. And his family attorney had only been retained for several weeks. The statement that he made that gave rise to the terroristic threat charge was made outside the presence of any alleged victim, and there is no indication that Mr. Allen took action to carry out any of his threat. The case was documented by the San Antonio Police Department and the Fusion Center, but it resulted only in an information report, not an arrest at the time. No firearm, no plan, no attempt, just words spoken in the distress amid his ongoing family court litigation and the emotional duress. Notably, the complainant himself, the attorney that he had, called the SAPD out of an abundance of caution, but he was not in fear. The compelling personal circumstances on this case are substantial because of in addition to the low risk nature of the alleged offense, Mr. Allen has experienced profound personal hardship because his father, Ronald Wayne Allen, passed away while Mr. Allen was incarcerated. He has been unable to grieve properly or to attend final arrangements. Family tragedy only worsens the financial burden of a high bond. We think that Mr. Allen needs help to grieve, to deal with these charges. It would also help for him to be able to manage his defense. You heard today from Evelyn Allen. She's the defendant's mother. She's a woman of modest means who has established her financial resources through her marriage with her husband, who recently passed. She's exhausting her financial resources trying to help her son, and she has testified that Mr. Allen has longstanding ties with the community, has never failed to appear for court, and she is willing to supervise him personally, and that the current bond amount is financially oppressive to their family. Your Honor, we are not asking the court to ignore the concerns of public safety, only to apply the law fairly. There's been no evidence that Mr. Allen poses a threat to any person if released. He does maintain there was a civil protective order between him and his prior lawyer because he's the one that made the report and the outcry regarding the terroristic threat. But he would abide by that protective order substantially. There is, however, evidence that the current bond amount is far beyond his means and his family's means, and we believe that it's unnecessary to secure his return to court. We are requesting at this time that the court consider reducing Mr. Allen's bond to a reasonable amount or releasing him on appropriate pretrial conditions, which may include GPS monitoring, counseling, or any mental health evaluation if the court deems such conditions necessary. We believe that this would align with the Code of Criminal Procedure, Article 17.15, as well as the constitutional safeguards designed to protect the rights of the accused while preserving public safety. From where I'm sitting, I recently became his second criminal defense lawyer, and it is a difficulty for me to prepare for a complicated, what's likely a complicated trial regarding this case. I've filed motions to suppress and a motion to dismiss this charge, but I'm not here on that today. I'd like to get my client released under a reasonable bond so that I can prepare and have him prepared for those hearings outside of the jail.
All right, state.
Judge, we believe that the bond has been set in a sufficient amount regarding public safety. Regarding the testimony that you heard from today, it sounds like, well, the mother does have limited needs. She does have several items of collateral available to her, and there's also this untapped resource and the defendant's own personal belongings, financial resources, and bank accounts that they've neglected to speak about for privacy reasons as testified to by her. And then regarding just the flight risk, I mean, he does have ties to locally Texas and Louisiana. So we would ask that you keep the bond amount at 100,000.
Judge, I guess if I may, with respect to the family resources, they are, she doesn't have a lot of access to a lot of the funds that might be available in their normal circumstances if Ronald's father was alive. Just weeks after Ronald was incarcerated or jailed, this man died. And so we believe, and Ms. Allen has advised me, that a number of those resources and properties are going to be tied up in probate in the coming weeks.
Well, let me just explain something. I don't believe that someone should be required to put their home up for collateral to make somebody else's bond. So I'll just lay that there. That is gambling to put your home up. Yes. Because the bondsman will take your mother's home if you fail to appear. Mm-hmm. So this is the court's issue. So I've read defense, I've read your motion. And in your motion, you put that Judge Hortek found that your client wasn't a threat to his son or the community at large, and that there will be a protective order regarding his ex-wife.
Yes, there is, Judge.
And that he will be allowed to proceed with his visitation rights. So I don't understand. On the civil side, they said he was going to have his visitation rights. It's going to be supervised, and they wanted a psychological evaluation. I don't understand how we go from that to now he's before me on a charge of terroristic threat. And Mr. Allen, I want you to know I don't take any of this as true because I haven't heard any evidence on the facts. The reason why I bring that up is because, as you stated, counsel, part of the things I consider in a bond reduction is safety of the community. So in this case, safety of the community would be based upon the indictment, the community at large, and also the protective order that your ex-wife has, her safety as an individual, but then the community at large, based upon the exhibits that the state had me read, which was part of the police reports. So that's the court's concern.
Well, Judge,
and has he done a psychological evaluation? Has that been done, or was that completed?
No, Judge. The order coming from the civil case, from my understanding, I'm not a civil lawyer,
Mhm.
but my understanding is that that final order in that Sapser modification that was filed by the ex-wife and was litigated while he was in jail through Judge Hortick, that is pending as far as the order being signed.
Okay.
There are judge's notes that indicate what I mentioned in my motion, that the protective order against the son was denied. There is, I think there's other ways to secure the community other than a $100,000 bond. I think a GPS or any kind of tracking would be able to secure compliance. And if there's a bond condition that prohibits his contact with either the complaining witness in the underlying terroristic threat case, or who I believe did get his own protective order, and then also a protective order, or rather a bond condition that prohibits his contact with the ex-wife, and ask him to remain in the jurisdiction. I think that can mitigate some of the risks of him not coming to court.
All right, and state?
I would just reiterate my prior arguments and then the testimony regarding his prior arrest.
All right, this is what the court is going to do. With regards to your other motions that you filed, the motion to dismiss and the motion to suppress, we'll set those for hearings and y'all confer. And I would like those hearings set as quickly as possible because that may end up addressing whatever issues are here. But Mr. Allen, I'm going to deny the motion to reduce bond. I'm going to order that there be partial GPS for employment only. GPS fees will be waived and there be a referral to Center for Healthcare Services. So if y'all would confer with Ms. Ferguson on having that motion to suppress heard counsel and also your motion to dismiss. And so if y'all speak to her, she'll tell me what's the date that you all both can agree on, and we'll make sure that hearing is heard.
Thank you, Judge.
All right, you're welcome. Thank you, counsel. And just come back to me once you get a date. Yes. State. Megan?
Yes.
Norma is telling me that his next court date is July 28th. Would you all be ready?
Because I haven't had an opportunity to reach out to the witnesses, I can't say for sure, but I'll do my best to have everyone ready.
All right, so counsel, if the state needs to have witnesses by Zoom, are you okay with witnesses appearing by Zoom, or you want them all in person?
I don't have any objections to witnesses appearing by Zoom.
All right, so defense said if need be, some can appear by Zoom. All right, so we'll put you down for next week, Mr. Allen, and if the state is able to have their witnesses sooner than Monday, they'll let defense counsel know, and we'll have you brought over sooner, all right?
Okay.
All right, thank you, sir.
Okie dokie, friends, it's time to call it a day. And it's been an interesting day, hasn't it? A couple of crazy hearings, couple of things I didn't necessarily expect to see, but saw, and, it's always something new here at the Courtroom Files, especially on the live show. You just never know what you're going to get. So I hope you all had fun. I know I did. Looks like our bear is going to hide for now. We'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. And I do have some things to say during that pre-show tomorrow regarding that gentleman who somehow managed to get a pardon recommendation in that one hearing. I've got thoughts. So we'll get into that on the pre-show. If you're not a channel member and you'd like to join us, go up to that pinned chat, click on that link, and you can become a channel member. All right, we'll see you all tomorrow. Go have yourselves a great Monday. Thank you all so much for all of your continued support. It's very much appreciated. Take care. God bless.